Miss Bridgewater,
Yes, ma'am.
did we send a consent bond orders?
You will send them to me.
All right, I'm gonna send a few over.
Thank you.
All right, good afternoon, everyone. Let's go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and at this calendar today, we will address matters for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, please be advised you have certain rights today, including the absolute right to remain silent. Anything you say can and will be used against you. You also have the right to counsel at this hearing today. As you can see, I am conducting this hearing by video. I am not there in person with you. That means any member of the public can log on and watch this proceeding. It's also being recorded. When I ask if you understand your rights, that is what I'm referring to. Even though we are in Zoom court, we do expect the same behavior and conduct as if you were in person with us. Those who are driving or in a moving vehicle will be removed from the Zoom conference. You must be in a stopped location when we address you or when you are addressing the court. Ms. Bridgewater, what is my reset date?
Yes, Your Honor, it's going to be April the 21st.
All right. Those who receive a signature bond will be reset. Further notice. Those who receive a surety or a cash bond today are going to our state all-purpose calendar on April the 21st, whereby aspects of the case, including bond or contact, can be revisited at that time. All right. I have all defense attorneys have the opportunity to interview their clients.
Yes.
Okay. And do we have any interpretation cases today? It's muted at courtroom too.
Oh, we don't have anyone.
Okay, thank you. Are there consent bonds today?
Yes.
Can we go ahead and do those first?
But before we do, we can start with number 14, Ms. Ellis.
Okay, we can't do that. How many? Okay, before we do that, how many consents do we have?
There were 5 consents from my cases.
What were they?
They are, I believe, 14. Miss Ellis is one.
Okay.
Yes, let me go to the top. So Mr. Edwards, position 12 is a consent bond.
Okay.
Mr. Algert, position 13 is a consent bond.
Okay.
14, Miss Ellis, consent bond.
I did not receive the bond, Ms. Tucker. Good afternoon.
Oh, I'm sorry. The PD responded they consented to all of them, and I must not have understood this was a conflict.
And what was the other one?
Um, Position 15, El Sayed was a consent bond.
Yeah.
And then 18, Mr. Hill.
All right, trust me, it goes faster if we can do those first. All
Yeah.
right.
Miss
Private attorney.
consent bond, but I don't know the terms.
Okay, 1 second, Ms. McLeod. All right, there are private attorneys on the line. If you would use the raise hand feature to sort yourself to the top of the screen so I can address you shortly after this case. Who are the private attorneys? I see Ms. Porter on the line. Ms. Porter, who's your client? It's cut off. I can't see who that. I not somehow it raised my own hand. That's very strange. I don't want to raise my own hand. Who's your attorney?
Francesca Davenport, and I haven't had an opportunity to speak with her.
You have not?
I have not. Can I
Is
speak
there
with
a
her?
phone? Is there a phone number where Miss Porter can give Miss Dav? Where is Miss Davenport? She's at ACDC.
Yes, Your Honor, I just need her cell number and I can call her.
Okay, Ms. Porter, please put your cell number into the chat, please. And chat only ACDC so we all don't end up with your phone number. Thank you so much. All right, and is there other private attorneys on the line?
Yes, Your Honor, Mike Jacobs for Lysandra DiMartino.
Okay, and have you interviewed your client?
Yeah, I have not, but I've represented him one time before and I've talked to his family, so I'm ready to handle a bond.
Okay. All right, we'll do that one once we do the consents. Thank you for holding, Mr. Jacobs, okay?
Thank you. Thank you.
All right. Are there other private attorneys on the line? All right, and if we could go ahead, Ms. Tucker, send that to Ms. McLeod so we'll know if it's a consent or not. Do you
Yeah.
represent Ms. Ellis? That's Ms.
I
McLeod?
do, Your Honor.
Okay, can we skip Ms. Ellis for a minute and let Ms. McLeod see if she's gonna consent to that? Can we do another consent? Can we do number 12?
Hold on.
I'm sorry, we're not ready on Ms. Ellis.
Okay, hold on.
Ms. McLeod, I sent that to your email.
I just looked, I didn't see it, but I'll look again.
I just sent it.
Okay.
Or can we take Mr. DiMartino then?
Yes. Hang on, Mr. Edwards. Yeah.
This is Edwards
Okay.
for the consent bonds.
All right, and as soon as we finish the consents, I guess we'll do Mr. DiMartino. Mr. Edwards, your case is 26 CR 002283L. In this case, you're charged with criminal trespass and damage to property. Ms. Stallworth, will you just put the history briefly onto the record?
Yeah, sure, Anna. Good afternoon.
Yeah.
Mr. Edwards has 9 cycles. There is 5 convictions, I'm sorry, outside of the 10-year period. Last date of arrest was in 2012 out of the cab for driving without valid license. The recommended level is level 2.
Okay. And what was the consent, Ms. Tucker?
Yes, Judge, we're consenting to $1,500 signature bond through pretrial level 1 with conditions no further contact with Tony Jean Mobley and to stay away from 122 Dogwood Drive in Atlanta.
Okay. Ms. Kim,
Yes, Your Honor.
based on the history that I've heard and pretrial's recommendation, I understand this is a consent, but I would be changing it to level 2. Do you still consent?
You vote twice. Yes, he still consents.
All right, so you so consent, sir, you're gonna be released on a signature bond at level 2 through pretrial services with those same conditions, okay?
How much that bond, how much the amount was again?
It was 1,500 SOB level 2.
Your Honor, may I have your permission to change this consent bond to level 2?
Yes, please, Ms. Bridgewater, I would appreciate if you would do that.
Okay.
All right, are we ready for either Mr. DiMartino or another consent?
Hold on one second, we get him.
Okay, I sent you a message in the chat.
I saw.
Okay.
Hold on, okay. Now, DiMartino's coming up.
Thank you. All right, Mr. DiMartino, good afternoon. Your case is 26 CR 002274E. You're charged with DUI and obstruction in this case. You understand your rights?
Yes, Your Honor.
All right, thank you, Ms. Stallworth.
Yes, Your Honor. He has 5 cycles total, multi-state interaction, 1 out of Florida, 2 out of New Jersey. And there are 3 convictions outside of the 10-year period, recommended level 1.
Level 1. Okay. Thank you, Ms. Tucker.
Yes, Judge. Although they are outside the 10-year period, one of his convictions was for a DUI in 1985, and then there was a DUI arrest in 2014 that was acquitted at trial. But he does have, prior DUIs. when I make my consideration. We are asking for 2,500 good on the DUI and 1,000 good on the obstruction for a total of 3,500 with conditions no drug, alcohol, or weapons while out on bond. The facts allege that officers dispatched to Avalon Mall. There was a report of a man with a broken leg needing assistance, but he fled in a car before they arrived. They did find his vehicle in the apartment complex where the registered owner of the vehicle was. He was waiting too long at a yellow light to turn with no oncoming traffic, which kind of alerted the officers that something was off. Then he was seen driving and stopping every 100 feet in this neighborhood. They eventually initiated a stop, and the defendant stumbled out of the car. They noticed a strong odor of alcohol. He said his leg was hurt, but he denied EMS. He began to start walking towards his apartment, and he was told he was not free to leave. He tried again, so the officers tried to grab him. He fell, and then he even started trying to crawl away. Eventually, he was stopped and handcuffed, read implied consent en route to the hospital, and refused. So, for these reasons, DUIs are very serious, community, high, you know what I'm saying. We're asking for the $2,500 good bond on the DUI, 1,000 on the obstruction, and a $3,500 total.
All right. And no other conditions?
The no alcohol, drugs, or weapons while out on bond.
Okay, thank you. Mr. Jacobs?
Judge, I think that's a fair bond the state recommended, so we would be fine with Your Honor agreeing to that.
All right, defendant is gonna receive, I'm gonna change it just a little bit. Defendant's gonna receive 1,500 on the DUI and 1,000 on the obstruction for a total of $2,500 surety. He is having no alcohol, drugs, or weapons, and his case will be reset to state all purpose on the 21st. Is there anything additional, Ms. Tucker or Mr. Jacobs?
No, Your Honor.
All right, with that, best of luck to you, Mr. DiMartino and Mr. Jacobs. Does that conclude your business?
Yes, it does, Your Honor.
All right, take care. Have a wonderful afternoon.
All right, thank you.
All right. Are we ready on Miss Ellis, Miss McLeod? You're muted, Miss McLeod.
Yes, Your Honor, we are ready on Miss Ellis, and this is going to be a consent bond.
All right, thank you. Is Miss Ellis ready? Thank you, Miss Ellis. Your case is 26 CR 002275Y. You're charged with simple battery. Miss Stallworth, ma'am. I'm sorry, Miss Ellis, do you understand your rights?
I guess so.
All right. Miss Stallworth, can I please have that history?
Yes, Your Honor. 7 prior arrests. There are 4 convictions outside of the 10-year period. FTA in 2014. Last date of arrest, June the 23rd of 2015 out of Fulton for a probation violation. Recommended level 2.
Thank you. All right, and the recommendation, Ms. Tucker?
Yes, Judge, we're consenting to a $1,500 signature bond, level 1, with conditions no further violent contact with Joyce McGee.
Yes, Your Honor, and because she is disabled, I'm going to ask that she be able to report telephonically.
Miss Stallworth, level 2 is how often? Once a week or once a month?
Twice a month, I think.
Twice a month?
I
I
think
think the
so.
state said level 1, Your Honor.
The state said level 1 recommendation was level 2. That's why I'm asking. I'm sorry, Miss Stallworth, what was the level 2 is how often?
I have to check really quick, but I'm pretty sure, I think it's twice a month.
Okay, I want to make sure before I decide.
Okay, I'm looking it up now.
Yes, Judge, when we came to when we recommended level 1, I believe her most recent was 2015. This did occur at a rehab center. Both of them are very elderly both in wheelchairs. So that's why we were consenting to signature level 1.
I'm not saying I won't, I just want to know how often it is.
Once a month.
Level 2 is twice a month, isn't it? I don't know. I thought so.
I'm looking at
It's been changed because level 1 used to be once a month, and I think level 1 is now as called in.
correct.
But I'm sorry, Miss Stallworth, how often is level 2?
It's saying once a month.
Level 1 is how often?
It's also saying once a month. I guess they put them on the same. I'm looking at the PSA sheet. They're both
Yeah.
saying once a month.
Okay. All right, we'll let her go at level
Oh,
one. I'm sorry, go
yes,
ahead, Ms.
yes,
Stallworth.
it's face-to-face reporting monthly
On
on level two. Level
level
two.
two. That's what I thought. All
Yes,
right,
I'm sorry.
she can report on level one telephonically. All right.
Thank you.
Miss Ellis, you're being released on a signature bond 1,500 at level one through pretrial with no further violent contact. Let's sound for Miss McGee. Is Miss McGee present by any chance and wishes to make a statement? All right, hearing none. Thank you. Best of luck to you, Miss Ellis.
Your Honor,
Yes,
I have a question. Can I write telephonic reporting, or would they like to do a new bond order to reflect that?
you can write telephonic. That's
Okay.
probably the easiest way.
Okay.
Is that fine, Ms. Tucker, Ms. McLeod, if Ms. Bridgewater just writes that on there?
Your Honor.
All
Perfect
right.
by me.
Okay, thank
All
you.
right, rather than having to do it all over.
Okay.
All right. All right. Best of luck to you, Ms. Ellis. That concludes your case. Who do we have next?
Position 9, and I also have position 9 and 11. Both of them are Attorney McLeod's clients.
9, it can be 11. Well, it would be
Wait,
9.
yeah.
Team. Miss Hall and Miss Davis are Miss Attorney McLeod's clients.
Okay, let's hold for 1 second. Can we do the other consents? Do we have Hill?
Yeah, we do.
Thank you. Hold on 1 second. We'll be back to ACDC in 1 second. Mr. Hill, your case is 26 CR 002281G. You're charged with simple battery family violence. You understand your rights? Is that a yes? Okay. Ms. Stallworth?
Cycles, multi-state interaction, one out of Minnesota. There's an active warrant out of Minneapolis, Minnesota for a probation violation. Date of that warrant is September the 10th of 2019. There's a 2019 conviction for check forgery. There's a 2023 NOLO out of Henry County for criminal trespass, and a 2016 first offender out of Gwinnett for computer theft and theft by taking. The recommended level is level 1.
Okay. All right, Ms. Tucker, this is a consent, correct?
Yes, a consent to $1,500 signature bond through level 1 with no further violent contact with Amanda Dinak.
All right, and Ms. Kim, that was your understanding?
Yes, Your Honor.
All right, is Amanda Dinek present?
Yes, I am.
All right, if you wish to make a statement, please turn your camera on, raise your right hand.
Yes, 1 moment.
Please do so quickly. Do you
Yes,
swear or affirm the testimony you give today will be the truth to the best of your knowledge?
yes, I do.
All right, what I'm most concerned with is concerns you have for your safety and desires for contact with the defendant. With those instructions in mind, what would you like to tell me?
I would like to tell you that's what I said. I don't know how to move forward with this because it is something that is false. I did say I didn't want to press charges. There was no physical altercation. It was verbal. We're still together as we speak.
Okay.
So
So I'm assuming no concerns about your safety and you wish to
not
have
at all.
contact? Okay. All right. I appreciate you coming to court and making that statement. Sir, you're going to be released on a $1,500 signature bond through pretrial services at level 1 with no further violent contact with the alleged victim in this case. Best of luck to you, Mr. Hill. Was that our last consent?
Yes, sir.
Did we handle 15, Farida Elsit?
Can we do number 15?
I believe, Your Honor, that is right here. I thought she was gonna have a private attorney. I just want to make sure there's no private attorney present, then I'll convey the message.
Is there a private attorney for Farida El Said?
No, Your Honor.
Okay, and I'm assuming that's a family member. All right, Miss El Said, your case is 26 CR 002277L. You're charged with simple battery family violence and battery family violence. You understand your rights?
Yes.
No, I'm sorry, the young lady in the courtroom. Do you understand your rights?
Yeah.
All right, Miss Stallworth, can I have the history, please?
There's no prior history, recommended level 1.
Okay, thank you. Miss Tucker?
Yes, Judge, we're recommending $1,000 signature bond on count one, 1,500 signature on count two, for a total of 2,500. Signature bond through pretrial level one. No further violent contact with her mother, Yasmin Goma, who's been speaking up on her behalf, and to complete an MHET while out on bond.
All right, and Ms. Kim, your client so consents?
Yes, Your Honor.
All right, and Ms. Goma, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, I do, Your
All
Honor.
right, thank you. Do you have any concerns for your safety, and do you wish to have contact with the defendant?
Yeah, I'm not concerned about my safety at all with her. It was just an isolated incident. It's not her typical behavior, and I'm not concerned about my safety. It's just my daughter had to call the emergency because I was having a panic attack. This is something I usually suffer from, but it wasn't related to any of safety issues with her or anything like that. And she's already doing counseling through therapy because again, we've been through divorce and some record of prior physical abuse. So she's getting the help that she needs.
I don't want you to
So,
say, Ms. Goma, I don't mean to cut you off. There'll be other proceedings where we can flesh this out, and I don't want you to
yeah,
say too much
of
by
course.
mistake, okay?
Yeah,
So I'm gonna release your daughter. All right, Miss El Sayed, you're gonna be released on a $2,500 signature bond at level one through pretrial services, 1,000 on count one, 1,500 on count two. You are gonna undergo an evaluation, but it sounds like from your mother's account, you've already begun some of that. You're to have no further violent contact with the alleged victim in this case. Is there anything additional from state of defense?
But can we make sure that we waive any cosigner requirement?
How old is she?
she's 17.
Okay. All right, I will waive the cosigner. All right, best of luck to all parties associated with this case. Ms. El Sayed will be released on a signature bond.
And
All right,
I have a question, Your Honor. So,
very quickly, go ahead.
so we'll be going to the jail to release her? Is this
She's
what's
gonna be able to sign herself out and somebody can come pick her up.
okay?
Okay?
Thank
All
you.
right? All right.
Okay.
All right.
I'll be there shortly.
No, don't
Thank you.
tell us that.
Yeah.
Thank you for
Thank
slowing
you.
us all down. Thank you so much.
Thank you.
All right, who do we have next?
Number 5, Mr. Butler.
Judge, 13 is also a consent bond, but I'm ready for 5 if we are.
Is number 13 present?
He waived his appearance.
Yes, Your Honor.
Okay.
He waived. I'm
Sorry,
ready.
we'll do that last. Okay. And one more thing, the private attorney, did Ms. Porter speak with her client? Is she back?
Yes, Your Honor. I am back. I
Can we
think
do that one? Hold on, real quick. Who was your client again?
Miss Davenport, Francesca
All right, is
Davenport.
Ms. Davenport there? Can we do her case? All right, good afternoon, Ms. Davenport. Your case is 26 CR 002267Y. You're charged with hit and run, reckless driving, 2 counts of driving on the wrong side of the road, and failure to obey a stop sign. You understand your rights? Is that a yes? Okay, thank you. Ms. Stallworth?
2 prior arrests, no convictions, recommended UJR jail.
Okay, thank you. Ms. Tucker?
Yes, Judge, we also had access to her driving history, which showed that she was a repeat offender for speeding. Which I
Hold on
think,
one second. What time was she booked in? I have that she was in jail for 3 days for this. Is that correct?
Yes, Judge. She turned herself in on Monday, and she's been sitting in jail since then.
Do we know what time she was booked in? Because this might be a Riverside.
She came in at 8 a.m. and then she had to wait for them to actually draw warrants before they actually booked her in. So I'm not sure exactly what
Can
time.
somebody tell me what her booking screen says? Let me look myself. Hold on.
What position is this?
Position 8, Ms. Davenport.
Thank you.
It's moving so slowly. Okay, so Ms. Tucker, you continue while I look for it.
okay.
115.
So we are actually asking for a split bond of 1,500 good on the hit and run, 500 on the reckless, and then the rest will be 250 signature bonds, for a total of $2,000 good, 750 signature.
Miss Grace, I'm sorry, Miss Grace, you said 1:15 she was booked in?
And 4/6/2026, 1:15, well, 4:20, showing 3 days. 4/6 at 1:20 p.m.
Oh, okay, I see, I understand. All right, continue, Miss Tucker. I'm sorry. Thank you, Miss Grace.
Yes, the facts allege the defendant was driving on the wrong side of the road. The victim swerved, but the defendant still sideswiped him, leaving scratches all down the side of the car, a dent, and a flat tire. The defendant did not stop at all, and the vehicle was identified with flock. Considering the flight risk here, I mean, she just kept driving. We are asking for that $1,500 good bond on the hit and run, 500 on the reckless driving, and 25 signature bond on the last 3 counts for a split bond, 2,000 good, 750 signature.
Okay. All right, Miss Porter.
Thank you, Your Honor. We would be asking for a straight signature bond. I don't have a problem with the amounts. However, she did turn herself in even before warrants were processed for her arrest. She's not she's not a flight risk. She actually takes care of her elderly mother. So she's been away from that responsibility for 3 days. She's a teacher at Atlanta Unbound Academy. So she has strong ties to the community. She does not have a record of anything violent. This was primarily, or actually purely, damage to the vehicle. No one was hurt. No one was hospitalized. So we would ask that we can do the entire 2750 if that's the court's order on a level one. I actually would ask for 1,500 total, but I'll leave the amount up to the court. I would just ask that it be a complete signature bond.
Okay, defendant is gonna receive a split bond. It's gonna be 500 on each count, so that's a total of $2,500 split. But she has to make bond on the first 2 counts. It'll be 500 surety on count one, 500 surety on count two, and 500 signature on each of the remaining counts through the jail for the total of 25. So she's gonna make bond on 1,000. Because she's receiving a split bond, her case is gonna be reset to April the 21st. She's to have no alcohol, no drugs, no weapons. Is there anything additional, Ms. Tucker or Ms. Porter?
Nothing further from the state.
Nothing from the defense, Your Honor.
All right. Best of luck to you, Ms. Davenport and Ms. Porter. Take care and have a wonderful afternoon.
Thank you.
Bye-bye.
You too.
All right. All right. I think we've got all the consents and all the private attorneys, and I'll just take whoever's ready at the jail. Who do we have next?
Number 5, Mr. Butler.
I'm here in the car.
Oh, that's Mr. Butler?
Yeah.
Okay. All right, Mr. Butler, your case is 26 CR 002296A. You're charged with possession of a pistol, pointing or aiming a pistol at another, and 2 counts of simple assault, family violence. Do you understand your rights?
You say that again?
Do you understand your rights today?
No, what you said before that?
Give me a second. Do you understand your rights?
Yes.
All right, you're charged with having a pistol, pointing a pistol, and 2 counts of simple assault, family violence. Okay. All right, Ms. Stallworth.
No adult history, recommended level 1.
All right, and pretrial accepts the chart count one still at this point, Ms. Stallworth?
That was the recommendation, Your Honor.
Okay. I've understood in the past, pretrial has some hesitation about count one. I was just curious. All right. All right, thank you, Ms. Tucker.
Yes, Judge. Despite no adult history, these facts are very severe. We're asking for a $1,500 good bond on the possession of firearm under 18, a $2,500 on the pointing of firearm at another, and 1,000 on each of the simple assault family violence. That's a total of 6,000 good, with conditions no further contact with parents Daquan Butler and Katrina Butler, and to stay away from 2748 Belts Bar Way in Riverdale. The facts allege that these victims called because their 17-year-old son had pulled a firearm on them during a dispute. The defendant had left by the time officers arrived, but they found him walking back towards the location. He did comply with verbal commands and was taken into custody, but the firearm, a 9mm pistol, was found in his waistband. A GCI check showed that he was on an ankle monitor for a theft by receiving felony out of Clayton County and was on probation for that. So, just based on these facts alleged in another, world, this could be an aggravated assault. So we're asking for that total $6,000 good bond. We have not been able to speak with either of the parents, so without their input, we are asking for no further contact and to stay away from this location.
He's 17 though, Miss Tucker. Well, okay, let's flesh that out. Who represents Mr. Butler? Mr. Butler, do you have an attorney? Did you speak to someone today?
No, I didn't speak to anyone today.
Does the public defender's office represent Mr. Butler?
We have at the school shift, so okay, I can take it. Okay, I can call and take care of it.
Okay, so someone's gonna speak with him. Let's see, is his parents on the line? Are either Daquan or Katrina Butler present? Okay, all right, if Miss Kim could give Mr. Butler a call, we'll be on hold.
Sure.
Yes, in the meantime, we need number 23, Mr. Clean.
Okay, Miss McLean, your case is 26 CR 002292L. You're charged with 5 counts of cruel, not five, is it 10 counts?
It's 10, Your Honor.
Yeah, 10 counts of cruelty to animals. You understand your rights today? Is that a yes? Okay, Miss Stallworth?
Yes, Your Honor. She has 10 cycles out of the state of Michigan. There is an open case out of Manistee County, Michigan for assault excluding sexual. The arrest date was July the 28th of 2019. No convictions listed, recommended level 2.
Thank you, Mrs. Sirocco.
Yes, Your Honor. This was the April 7th incident, so just yesterday at 995 Palmetto Ave in Atlanta. Officers responded to an animal call at the location, and the caller had reported that multiple dogs had been left inside of a red truck for several hours. The officer found the vehicle in question when he arrived and saw initially 2 adult dogs and at least 4 puppies. It turns out that number was greater. The officer approached the house, knocked on the door, and didn't get an answer, but ran the vehicle tag, which returned to the defendant. Officer tried contacting the defendant via phone number, unsuccessful there. But there was excuse me, further law enforcement arrived, and that officer observed dogs inside the vehicle. At that time, used a temperature reader, showed the interior temperature of the vehicle was between 94 and 95 degrees. This they noted that there were 2 adult dogs and 8 puppies, and the adult dogs were, along with the puppies, all the animals were panting heavily. And when the officer opened the door, confirmed it was extremely hot. There was no ventilation in the vehicle, no food, no water. And the officer received a phone call from the defendant who said she'd left the location but hadn't been gone long. But based on the calls, it was evident that the dogs had been in there in that condition for at least 40 minutes. And the defendant was ultimately arrested here. Currently, bond is set at a $10,000 surety. They charged 1 count for whatever reason for all 10 of these dogs, but there's hence the $10,000 surety. With the underlying facts here on that one count, we have added 9 charges for the 9 other dogs here, being that there were 10 total. We were fine with that 10,000 surety remaining in place, but we would ask that it be allocated between the charges at 1,000 surety each. We feel that's appropriate given the alleged facts here. No pets of any kind to include canines while out on bond, and no drugs, weapons, or alcohol while out on bond.
All right, thank you. Is Miss Anthony, is this your client?
Yes, Your Honor.
Yes, Your Honor. All right,
I'm sorry, we're just asking for either a signature bond be granted or the lowest possible bond. Miss McLean has been in Georgia for 3 years after the passing of her mother. She does have a significant other as well as she moved here with a prior spouse. She has been in restaurant and food management for over 2 years, and she is on limited financial income to support herself. Given that the current bond would be extremely financially burdensome on her and likely will not be able to make that. So we're just asking the court to consider the lowest bond if possible, if not a signature bond in her case.
all right, thank you. Let me see, hold on 1 second. Okay, hold on. These were alleged to be her animals?
Yes, Your Honor.
Okay. Hold on. So bad in there. Let me do something easier. Okay, defendant. That feels too long. Give me 1 second. All right. All right, to make it, defendant is gonna receive a $2,250 surety bond, which will be $250 surety on each count. She's to have no alcohol, no drugs, no weapons, and the case will be reset to state all purpose on the 21st of April. Is there anything additional?
No, Judge.
Judge, what was that amount again total, please?
2,250. It's gonna be 250 on each count. All right. Who do we have next? Best of luck to you.
Position 9, Miss Davis.
All right, good afternoon, Ms. Davis. Your case number is 20, nope, that's not it. 26CR 002270C. In this case, you are charged with battery family violence. You understand your rights?
Yes, ma'am.
Thank you, Ms. Sawyer.
One moment, Your Honor. My apologies. It's 6 cycles. There's an open case out of Clayton County for DUI. Arrest date June the 19th of 2025. There's a 2015 conviction out of Henry County for DUI and a 2010 out of Perry Municipal for theft by shoplifting. Recommended level 2.
All right, thank you. Ms. Tucker?
Yes, Judge, we're asking for a $2,500 good bond with no further contact with Tristram McLendon to stay away from 2453 Coronet Way in Atlanta, and to have no drugs, alcohol, or weapons while out on bond. These facts allege that a witness, Brittany Bortles, called because there was an altercation between a male and a female in the apartment above her. Another witness, Brian Blahery, saw the defendant and victim in a tussle. They were grabbing each other's hair. He observed the kids hitting the victim, the kids of the defendant hitting the victim. And that's when the witness Bortles saw, called 911. The victim had visible scratches to his face, neck, chest, and a small scratch on the back of his head. We were unable to get in contact with him, but based on the violence alleged, as well as that recent history out of Clayton, we're asking for a $2,500 good bond with conditions no further contact with Mr. McLendon and to stay away from that location and no drugs, alcohol, or weapons while out on bond.
All right, thank you, Mr. McClendon. I see you on Zoom. If you wish to make a statement, please unmute and raise your right hand. All right, statements are not required, but again, I'm sounding for Ms. McClendon. If you wish to make a statement, this is your opportunity.
No, I don't got no. I don't want to make no statement.
Okay, I appreciate you coming to court. All right, Ms. McLeod, is this your client?
Your Honor, my client is 35 years old. The case that was mentioned in Clayton County has actually been resolved, and it has not been resolved as a DUI, Your Honor. My client is the mother of two young children. They are, I believe, she has a 7-year-old and a 10-year-old. She is gainfully employed. This was not a call by Mr. McLennan. I had the opportunity to speak with him, and he indicated to me that he would like to have contact with my client as they share two children. So he has no issue with having contact with her. I would ask a signature bond for my client, Your Honor, given that she has no significant criminal history and certainly not a violent history. Nothing further, Your Honor.
Okay. Defendant is gonna receive a $1,500 surety bond. She's to have no contact with the alleged victim and stay away from that location. They can coordinate transfer of a child through a third party. Um, and if she needs to return to that location, she can do so one time with a member of law enforcement to do so.
She doesn't live there, Your Honor, but they do share the 7-year-old and the 10-year-old.
All right, so no need for LEO. She's to have no alcohol, no drugs, no weapons, and will be reset to all purpose on the 21st. Is there anything additional? All right, best of
Nothing
luck to you,
further, Your
Ms.
Honor.
Davis. All right, who we have next?
27, Ms. Riley.
All right, Ms. Riley, your case is 26 CR 002293E. You're charged with battery, family violence, simple battery, family violence, and simple assault, family violence. Do you understand your rights?
Yes.
Thank you, Ms. Sauer.
Prior arrest, currently on probation, case number 20 SC 177167 for homicide by vehicle first degree. There is an open case from the city of South Fulton for giving false name and driving while license suspended or revoked, recommended level 3.
Okay, thank you. Mr. Siraka?
Yes, Your Honor. This was a March 27th incident. Officers were dispatched to a fight in progress call and made contact with the victim, Mr. Jeremy Morgan. He explained the defendant, his ex-girlfriend, with whom he had lived for 10 months, had come over to his sister's home. And he explained at first the defendant was not bothering him. It was just parked outside the residence. Shouldn't be driving under that probation for the 20 SC case. But in any case, after showed up, there were no issues initially. The conversation then took a turn, and the defendant tried to strike him with her car door. He avoided being hit by it, but it was at that point the defendant hit him on the right side of his face with her phone. Officer observed swelling to the right side of the victim's face, which was captured on body worn. The defendant left the scene after this incident, so that is why there was an initial arrest here. Um, but the state's recommendation, with our history and with us having not been able to make contact with Mr. Morgan as of yet, we would, of course, ask the court sound for him when appropriate. But we're recommending a $3,000 total surety, $1,500 on the battery, family violence, and $750 on each simple battery, family violence, and simple assault, family violence. We would recommend 2 days anger awareness, no further contact with Jeremy Morgan. Stay away from 2940 Grand Avenue in Atlanta, as well as wherever the victim resides. I understand this location was his sister's home. So stay away from the victim's residence, and no drugs, weapons, or alcohol while out on bond.
All right, is Jeremy Morgan present, wishes to make a statement? All right, you need to unmute and raise your right hand. All right, do you swear or affirm, raise that your right hand? Please raise your right hand. Thank you. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, I'm most concerned with concerns you have for your safety and desire for contact. What would you like to tell me in light of those instructions?
Ain't got no desire for my safety. I can barely breathe without her being around me for real, for real. I mean, like it was just a misunderstanding. The officer really finessed me for real, for real. He was acting like he was on my side, but then shit, when this happened, I
Okay,
apologize for
let's watch.
cursing. I
Okay, thank
apologize,
you.
yeah.
Thank you. Go ahead.
When this happened, it really just struck me like crazy. I've been calling the prosecutor. I've been calling everybody I possibly can, and she been arrested for 10 hours. You understand what I'm saying? So I mean, like, uh, I don't got no concern for my safety, and I mean, like, I want to have contact with her, but I'm pretty sure she ain't gonna never talk to me again after this. So
Okay. I appreciate you coming to court and making that statement, Mr. Morgan. All right, who represents Miss Riley? Is someone here to speak for Miss Riley? Was this Miss Kim's case and Miss Kim was on the phone?
No, Your Honor, it was me. My apologies. I was trying to
Okay.
get um yes, Miss Riley, we do have a good address for her. As he stated, they are back together in on good terms. She is originally from Florida, but has been in Georgia for 23 years. Is a high school graduate as well as college, and owns and operates a restaurant and grocery store in Union City. She does have a 4 and 11-year-old child that she does take care of. Your Honor, given that this location is her property, he doesn't reside there. We just ask that there be a signature bond granted in her case.
All right, defendant's gonna receive a $1,500 surety bond. It'll be 1,000 on count one and 250 on each remaining count for the total of 15 surety. She's to have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons, and her case is going to all purpose on the 21st. Is there anything additional?
I have a different address for her. Is that you're saying she lives here? That from what I can tell, the sister lives here. I understand the judge is not ordering a stay away here, but just for clarity's sake here.
Briefly, Ms. Anthony, if you know, but again, there's no stay away and I didn't do a no contact. There's a no further violent contact. So perhaps we can figure that out. All right, Ms. Riley, best of luck to you. That concludes your case for today and to all parties concerned.
Your Honor,
Yes.
for Mr. I'm sorry, for the individual Captain Winfrey, I was trying to get in contact. I was seeing if someone can put us on a breakout room or if they can give me a call to speak with him.
Okay, or did Ms. Kim speak to him? I think she went to speak to him. Is that what happened?
No, Your Honor, she was unable to, so I'm gonna just try to dial in.
Okay. Ms. Grace, can you put Miss Anthony in with the gentleman that says Captain Y Winfrey so she can interview him?
You're good?
Yes.
Ms. Kim, talk to him now.
Oh, Miss Kim is on there now, Miss Anthony.
Okay, thank you.
All right. Can we take a case that belongs to Miss Anthony then?
Number 6.
I'm sorry, number 6. You said 16?
Number 6.
Oh, number 6. Thank you. All right. Good afternoon. Your case, Mr. Cheney, is 26 CR 002261J. You're charged with simple battery, simple assault, and obstruction. Do you understand, right?
No.
All right. Thank you. Ms. Stallworth, may I have this history, please?
Yes, Your Honor, there are 47 cycles. Currently on probation out of Rockdale County for aggravated assault and battery family violence, subsequent conviction. There's a 2018 out of Rockdale for battery family violence first offense and simple assault family violence. There are 24 convictions outside of the 10-year period. And there are FTAs outside of the 10-year period as well, 3 of those, and the recommended level is level 3.
Thank you so much. All right, Ms. Tucker?
Yes, Judge, you did hear that extensive history. We're asking for a $2,000 good bond on the simple battery, 2,000 good on the simple assault, 1,000 good on the obstruction, for a total of 5,000 total good bond. No further contact with Franchon Campbell, and to stay away from the gas station at 3819 Jonesboro Road in Atlanta. These facts allege that the officers saw the suspect from the 911 description. They attempted to detain him first, but he took off on foot. Then they spoke with the victim. She said the defendant allowed her to sit in his car while he walked away to a nearby gas station. When he came back, he asked her if she had any crack, to which she replied no. He did not accept that answer. He punched her in the head and the body multiple times. He also held up a metal rod and threatened to bust her in the head, although he did not hit her with it. That's why it's simple assault. And an anonymous witness saw all this and called 911. So, between the obstruction, he fled as soon as he saw the officers. You did hear he has multiple FTAs in his history. We believe he's a flight risk, risk as well to this witness and victim. So we're asking for that $5,000 total good bond, no further contact with Miss Campbell, and to stay away from this location. Additionally, no alcohol, drugs, or weapons while out on bond.
All right, is Ms. Campbell present, wishes to make a statement? All right, hearing none, Ms. Anthony?
Yes, Your Honor. We do have a good address for him on file. Mr. Chain did state that he has been working with Chili's as a kitchen manager for 20 years, with over 20 years in the culinary and restaurant industry. He did let me know that he is the primary caregiver for his mother. He is married and has children. In regards to the date of incident, he was saying that he was having trouble with his vehicle when this woman jumped into his car and began acting erratic and seeking drugs. So it was not a thing of an invitation in or anything, but trying to get someone that he felt was unsafe out of his vehicle to continue on with his day. He is a lifelong Georgia resident and college graduate from Georgia State and Griffin State for culinary.
All right, defendant is going to receive a $1,500 surety bond, 500 on each count. He's to have no contact with the alleged victim, stay away from that location, and have no alcohol, no drugs, no weapons. His case is going to state on purpose on the 21st of April. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Mr. Cheney. Who do we have next?
Woman number 5.
All right, we're ready for number 5. We've gone through. Can we very briefly, Ms. Tucker, just put your recommendation back onto the record?
Yes. On count 1, possession of a firearm under 18, I was asking for $1,500. On count 2, pointing a firearm at another, $2,500. On counts 3 and 4, simple assault, family violence, $1,000 on each. That's a total of $6,000 good bond, with no further contact with Daquan or Katrina Butler, and to stay away from 2748 Feldspar Way in Riverdale.
All right. And Ms. Kim, you spoke to your client?
Yes, I did, Your Honor. I was able to speak to my client, who is only 17 years old, Your Honor. Shall I go ahead or shall we call for his mom and dad? The alleged victims are his mom and his dad.
Correct.
And he's only 17 years old. He came from New Jersey, 2019. He has no children, of course. He's senior at Skyview High School. He plays football. He's very good at music. He wants to go to college as soon as he's graduating this year. He's only like 1 month away from graduating from high school. And he does stay with his sister, so he does not have to stay with his mom and dad, but he prefers to have a no further violent contact, being 17 yet. Until he becomes 18, he wants to have a contact with them. Your Honor, he has no drug abuse, nothing. He's very healthy. This is his first arrest ever. We will request for signature on bond, and he denies the allegations. He was not pointing at anybody or assaulting anyone. He's the one who feels like he was a victim in this situation. Thank you.
Does he have a co-signer? Because with this charge, if I do send it to pretrial, I'm not inclined to waive it, Ms. Kim.
His sister can be a co-signer. Let me get the name of the sister.
How old is his sister?
Mr. Winfrey, how old is your sister?
My sister is 22 years old.
She's not gonna be old enough. You have to be 25, I believe.
28 is older than 20. Did you say 28, Mr. Winfrey, Mr. Butler?
I said 22.
She's 22.
Oh, never mind. I texted his mom and dad, and I'll try to follow up to see if any of them will become co-signer, Your Honor.
Okay, and preferably because they're the victims, they can't be the co-signer either. So he
Yeah.
would need another adult relative. If you could work on that while we go through the calendar. All right, here's what I'm inclined to do. At this time, defendant's gonna receive a $5,000 signature bond at level 2 through pretrial services per judge. I'm sorry, it's 4,000 because it's 4 charges. 1,000 on each count. He is to take a 2-day anger awareness course. He's going to do 20 hours of community service, and he is going to have a curfew where he's digitally monitored through pretrial, where the curfew will be from 9 p.m. to 6 a.m. And if he's at work or at school, the curfew would not apply. Otherwise, he is to be at home. All right, and Ms. Kim, please work on let's see what we can do because I would prefer, in light of the charge, for him to have an adult co-signer. All
Yes,
right.
calling around. Thank you.
All right. Best of luck to you, Mr. Butler. That concludes your case for today.
Thank you.
Next is position 17, Miss Hall.
All right, Ms. Hall, good afternoon. Your case is 26 CR 002282G. You're charged with battery family violence. Do you understand your rights?
Yes.
All right, thank you, Ms. Sauer.
No prior history, recommended UJR jail.
Thank you, Ms. Tucker.
Yes, Judge, we are gonna agree to a $2,500 signature bond through level 1. We didn't have contact with the victim in time to do a signature bond or a consent bond, but we are fine with a $2,500 signature bond level 1 with no further violent contact with Jamal Hawkins. We did speak with him. He said that him and the defendant have been on and off for about 6 to 7 years and were living at this incident location for about a month and a half. They have 2 children together. He said the defendant was under the influence of alcohol at the time. So that is what caused this to happen. The facts allege the victim came to the front desk of a hotel asking for first aid items because he was actively bleeding. He said he was attacked by his child's mother who left the scene. He did have a scratch on his face, lumps on his forehead, and bleeding on a lump near his eye and on his finger where he was bitten by the defendant. However, the victim says he does say there is a history of violence between them, but he didn't want to elaborate. He is fine with a signature bond, and because there is no prior history, we're okay with that as well.
All right. I'm gonna sound for Jamal Hawkins at this time. Is Jamal Hawkins present? Wishes to make a statement. Hearing none, Ms. McLeod, any objections to the signature bond?
No objections, Your Honor.
All right.
I wanted to ask about the condition. Is this no further violent contact because they do share 2 children?
Yes, it was.
Okay, we're fine with that, Your Honor.
All right. Defendant is going to receive a $2,500 signature bond at level 1 through pretrial services. She's to have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons. Best of luck to you, Ms. Hall. That concludes your case for today. You're being released on the signature bond. All right. Who do we have next?
Your Honor, that concludes my business before the court this afternoon. May I be excused?
Take care, Ms. McLeod. Have a good day.
You too. Thank you.
All right, number 10, Ms. Davis.
Are you saying, I'm sorry, 2 minutes. Okay, number 10. Oh, no, you're muted. We can't hear you.
Position 2, so I can take her to medical, please.
Oh, okay, I'm sorry. Good afternoon, Ms. Bradshaw. Your case is 26 CR 002260C. In this case, you're charged with battery, family violence, simple battery, and cruelty to children in the third. You understand your rights? All right, Ms. Stallworth.
No prior history, recommended UJR jail.
All right, thank you, Ms. Tucker.
Yes, Judge. After reviewing the facts and speaking with the victim, we are not recommending a signature bond. We're asking for $1,500 good on the battery family violence and then $1,000 each on the other two counts for a total of, I believe that's $3,500 with no further contact with Jeffrey Bradshaw and to stay away from this incident location at 5560 Sable Bay Place or Sable Bay Point in South Fulton. The facts allege that this defendant had sent a video of herself with another man to her husband, who's the victim, which led him to question whether his son, if he was really the biological father. Excuse me, if the daughter was the biological father. So the defendant was going to the victim's place to get the daughter and pick up her stuff. The victim did not want the defendant to come in, but she pushed her way past everyone, causing the witness or the victim in the simple battery, the victim's grandmother, Michelle Henderson, to fall. They determined that the defendant was the primary aggressor and began the physical altercation, leaving the victim, Mr. Bradshaw, with a cut on his finger and bruising to his right forearm, and all of this was in front of the minor child. We did speak with the victim, Mr. Bradshaw. He said they had been married for 7 years, separated for about 6 years, though. The defendant lives in New York and the victim lives here. That he confirmed all the events in the warrant, says that the child has been in the defendant's custody for about 6 months, but that this is the first time being violent with him, but he would still like no contact and to stay away from him and his child. Now, he would like a cash bond. We're not asking for a cash bond. We're only asking for that $3,500 good bond in this case, with no further contact with Jeffrey Bradshaw. Also, that the grandmother, no further contact with Michelle Henderson, and to have no further violent contact with the juvenile child.
All right. Is Jeffrey Bradshaw present, wishes to make a brief statement? If so, please unmute and raise your right hand. Hearing and seeing none, Ms. Anthony.
Yes, Your Honor. Ms. Bradshaw has stated she does live in New York, excuse me. As she does have primary custody of the child. Your Honor, giving the allegation that we read off, Ms. Bradshaw would just like to provide that. Well, she reports that the reason for the entry is because there are threats being made to the child. So this wasn't just an act of defiance or anything, but as a protection that the child's well-being was being threatened. Given that they do not reside together, and she is gainfully employed, Your Honor, we just ask that you would grant a signature bond in this case for the lowest bond possible.
All right, defendant is going to receive a $3,000 signature bond through pretrial services at level 1. Because she's out of state, I'll allow her to report via phone. The breakdown will be $1,000 each count. She is to have no contact with the alleged victim and stay away from that location. They can coordinate transfer of the child through a third party. She's to have no alcohol, no drugs, no weapons at this time. Is there anything additional? All right, best of luck to you, Ms. Bradshaw. That concludes your case for today. Who do we have next?
Number 10, Mr. Davis.
All right, Mr. Davis, your case is 26 CR 002285G. You're charged with disorderly conduct and terroristic threats. You understand your rights?
Yeah, it was. Yeah.
Thank you. All right, Ms. Stallworth.
There are 49 cycles total, multi-state interaction, in both North Carolina and South Carolina. There are 16 convictions outside of the 10-year period. There is a 2024 conviction for criminal trespass and damage to property out of Fulton, a 2023 theft by shoplifting out of Fulton, 2022 theft by taking and entering auto out of Fulton, 2019 aggravated assault out of Fulton, and a 2016 forgery first degree out of Fulton. There is a 2022 FTA and a 2019 FTA. The recommended level is level 3.
Thank you. Ms. Tucker?
Yes, Judge, we're asking for a $1,500 cash bond on each of these charges for a total of $3,000. If you're not inclined to give a cash bond, then we would ask for $3,000 good on each for a total of $6,000 good, with conditions no further contact with this victim, Raina Edgar, and to stay away from Maiden Lane and Bonaventure Avenue. The victim does not want her exact address to be known, but as long as he stays away from Maiden Lane and Bonaventure Avenue, that should be fine. The facts allege that this victim was walking from her apartment to a local pizza store where she had ordered a pizza, and the defendant, a complete stranger, approaches her and starts threatening her, saying, "I'll kill you, bitch." She ran into the pizzeria. On her way home, though, he was still there. He found her, he crossed the street to come follow her, and he continued repeating, "I'll kill you, F you, I hate you," out of nowhere. So eventually, finally, she made it close enough to home that neighbors could hear her yelling for help and helped get him away from her. We did speak with this victim. She confirmed the facts in the warrant and, is just obviously in a lot of fear of this man. There's no reason for him to come up and do this. You also heard he has the history of violent felonies, notably 19 SC 167157, that's aggravated assault and terroristic threats felony. She should be on the Zoom and would like to speak if possible. But for those reasons, we're asking for that $3,000 cash only bond. If not inclined to give cash, then no less than a $6,000 good bond, 3,000 on each.
All right. Please mute. All right, Ms. Edgar, I see you on the, please mute Ms. Graves. And Ms. Edgar, I see you on the Zoom conference. If you wish to make a statement, please turn on your camera and raise your right hand.
I'm in Zoom call.
Oh, please mute that.
I am not.
Ms. Edgar, why don't you turn on your camera if you wish to make a statement?
I am trying. I don't exactly know how. I've never done this before. Hello? I'm not sure how to turn this on. Hello?
All right, please raise your right hand. Do you
Okay.
swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell me?
It's basically been said. I do not know this man. I was only going to get food and come home. He followed me all the way home, threatening to kill me. I have witnesses that he was chasing me. I have a security guard witness that was chasing, that saw this. And I am now, because he specifically said he would kill me multiple times, and then came back to my property the next week and sat on the steps for 30 minutes. I consider that stalking. I am terrified of him, and I don't know him, and I am in fear for my life.
All right. Thank you, Ms. Edgar. I appreciate you coming to court to make that statement today.
Thank you.
All right, Ms. Anthony.
Yes, Your Honor, for Mr. Davis. He did confirm the address on file is a good address for him. He's been there for about a year. He stated that he's originally from North Carolina and been in Georgia for 10 years and has 3 years of landscaping experience.
All right. Defendant's gonna receive $1,000 cash fine, 500 on each count. He's to have absolutely no contact with Ms. Edgar and stay away from the location. He's to have no alcohol, drugs, or weapons, and in light of the $1,000 in cash, he is going to be reset to state all purpose on the 21st. Is there anything additional? All right, best of luck to you, sir. That concludes your case. Who do we have next?
Number 16, Mr. Gilliard.
All right, Mr. Gilliard, good afternoon. Your case is 26 CR 00228. I'm sorry, 68Y. You're charged with DUI, speeding, giving false information, and driving without a valid license. You understand your rights?
Yes, ma'am.
Ms. Stallworth?
He has 5 cycles total. He's currently on probation out of Walton County for theft by taking. also on probation out of Newton County for criminal attempt to commit a felony and battery. There's a 2018 conviction out of Newton County for driving without valid license, theft by receiving stolen property, and giving false name. There's a 2018 first offender out of Newton County for criminal damage to property, second degree, and criminal trespass, and a 2018 out of Rockdale for driving without valid license, recommended level 2.
Thank you. Mrs. Sirocco?
Yes, Your Honor. This incident took place April 6th, 2026 here this year. This is at the State Bridge Road, where that meets Brookshire Lane Drive in Johns Creek. There was a speed enforcement officer set up there, and the defendant rolled by in his vehicle, driving at around 60 miles per hour estimated. It was in a 45. Officer actually confirmed that was 62 miles per hour with his radar gun here. The traffic stop was initiated, and the driver's side door upon the stop flung open. The driver had hopped out of the vehicle, was trying to distance himself from it. Officer made contact with the driver, now identified as the defendant, but he initially identified himself as Jihad McChair, with a date of birth of July 25th, 2003. That was determined to not be his name, nor his date of birth. Officer detected a strong odor of alcoholic beverage coming from his breath while speaking with him. He was slurring his speech, had bloodshot, watery eyes, and became increasingly fidgety, unable to remain still, and appeared nervous. The officer, the defendant revealed subsequent to this, while the officer was putting his information in and running that he had provided a false name and date of birth, provided his actual ID, and stated he was scared because he was on parole, and that he had a learner's permit and an expired license, learner's permit in Colorado, expired license in Georgia. It was confirmed that there was no driver's license ever having been issued here. He did admit he had shared a club tail, presumably an alcoholic beverage, with his boyfriend. That was around earlier that evening, late in the night though, and field sobriety tests were conducted. 4 out of 6 on the HGN, 6 out of 8 on the walk and turn, and 3 out of 4 clues of impairment on those tests, and there was a positive PBT as well. With his history here, this is not his first time driving without a valid license, 2 prior convictions. And this being a public safety case, the state's recommendation is going to be a 3,500 total surety, 2,500 on the DUI, and oh, excuse me, 2,000 on the DUI and 500 on the remaining counts, driving without a valid license, speeding, and giving false information to law enforcement officers. That is all for the state on this case, Your Honor.
Thank you. And is this your case, Ms. Anthony?
Yes, Your Honor.
All right, please
Speak,
proceed.
I'm sorry.
Please proceed.
For Mr. Gilliard, he did confirm the address on file is a good address from him. He is originally from Colorado Springs, has been in Georgia for over 10 years. He has work history in a brewer house as well as grocery retail and yard work. Currently working with Zane's Kitchen, a project with Zane's Kitchen in Duluth. And he does have significant ties to Georgia, family in Georgia, his mom and siblings. And I do believe Miss Gilliard attempted to get on in his support that he does have familial support here in Georgia. Just trying to see if she's on. Yes, Miss Consuela Gilliard is here on his behalf just to show the support for the family. So, yeah, we just asked for a signature bond be granted in this case, or the lowest bond the court is willing to consider.
All right, thank you, Ms. Anthony. Defendant is going to receive a $2,500 surety bond. It'll be $1,500 on the DUI, $250 on the speeding, $500 on the false information, and $250 on the license, for that total of a $2,500 surety. He's not to drive unless he has a valid license. He's to have no alcohol, no drugs or weapons, and he is reset to state all purpose on the 21st in light of the surety bond. Is there anything additional?
Did Your Honor say no driving without a valid license?
I did.
Okay, thank you. Just want to confirm.
Yes. All right, best of luck to you, Mr. Gilliard. That concludes your case for today. Who do we have next?
One, Mr. Alda. Oh,
Your Honor, I apologize for interrupting, but I just wanted to let you know that Mr. and Mrs. Butler, the parent of Mr. Butler, is on the Zoom, and they are not afraid of their son, Your Honor. Actually,
Okay, that's fine. Who's gonna be, I'm gonna let the no contact stay for now. Do they have you identified a co-signer that's not them?
oh, we could find 5 years older yet. We're trying right now, asking around the friends, but it's not easy, Your Honor.
I'm sorry, say that again?
We are trying to find one, but it's not easy, Your Honor. I was wondering if one of his parents could be co-signer, Your Honor.
They're the alleged victims, Ms. Kim,
Yeah,
so.
sorry. Or can we have a exception for his sister to be a co-signer?
Let's continue to try and let me think about that, all right?
Thank you, Your Honor.
All right, who do we have next?
number one, Mr. Aldana Pardo.
All right, Mr. Aldana Parado, your case is 26 CR 002289K. You're charged with criminal trespass. You understand, right?
Yes, ma'am.
Thank you, Ms. Stallworth.
There are 2 cycles total, one from ICE. There is an open case out of Alpharetta for theft by shoplifting, recommended level 2.
All right, thank you. Ms. Tucker, most concerned with where this location was and if I'm assuming he'd been previously told to not come back there.
Yes, Judge. He was arrested from this location the morning of that other theft by shoplifting out of Alpharetta. That's from this morning. So he got picked up, was given a signature bond in Alpharetta, and then immediately returned to this. It's the Target at 6000 North Point Parkway in Alpharetta. And, he told the officers, I know I'm not supposed to be here, but I need a receipt for DoorDash. So he thought, I don't know, that would take precedent over a court order to stay away from that location. So for those reasons, we're asking for $1,000 good bond and a stay away from the Target. It is at 6000 North Point Parkway in Alpharetta.
All right, thank you. Is this Miss Anthony, Miss Kim?
It's mine, Your Honor.
Please proceed.
Your Honor, given that Mr. Aldana has been here in Georgia for 2 years, he did confirm the address on file is a good address for him. He did say in regards to the DoorDash, he's been DoorDashing for 8 months to provide for himself financially. He did understand, but he, in trying not to lose his job, was just trying to seek understanding in the incident. So we just asked that the court impose the lowest bond, if not a signature bond in his case.
All right. Defendant is going to receive $1,000 surety bond. He's to stay away from that Target location, have no alcohol, no drugs, no weapons. Is there anything additional? All right. Best of luck to you, sir. Well, you know what I'm going to do? I'm going to make that. Sorry. Hold on. I'm going to look at one thing. Hold on one second. All right. I'm going to make this a $25 cash bond instead and stay away from that Alpharetta Target. Have no alcohol, drugs, weapons. All right. Best of luck to you, sir. That concludes your case for today. Who do we have next?
Add on one, Mr. Burns.
Okay. All right, Mr. Burns, your case is 26 CR 002299L. In this case, you're charged with battery, family violence. You understand your rights?
Yes.
Thank you, Ms. Stallworth.
Your Honor, he has 7 cycles total, 5 from Mississippi. There are 4 convictions outside the 10-year period, and there's a 2022 conviction out of Fulton for battery family violence. The recommended level is level 2.
Thank you. Ms. Tucker?
Yes, Judge, that battery family violence conviction is against this exact same victim. For those reasons, we're asking for a $2,500 cash bond. If you're not inclined to give cash, then a $5,000 good bond with conditions no further contact with Shunta Burns, as well as to stay away from 7985 Snapwell Drive in Fairburn. This defendant and the victim were arguing. They are married, and the defendant snatched the cell phone from her, told her to leave. So she grabbed his shirt to try to get the phone back from him. In turn, the defendant grabbed her, pushed her into a wall, continued to grab her and throw her around, push her out of the house. When she got back in the house, he threw her down on the sofa and choked her. She had multiple bruises on both arms. Additionally, you heard the 22 CR 002783H was a guilty conviction. For causing lacerations to her from punching her. So we have sent an email to get this transferred up as a felony subsequent battery family violence. Mr. Hutcherson, who usually handles the transfers, is out today. So for those reasons, we're asking for a $2,500 cash only bond. If not cash, then no less than $5,000 good bond, with conditions no further contact and to stay away.
All right, is Ms. Burns present and wishes to make a statement? Hearing none, Ms. Kim.
Yes, Your Honor. Mr. Burns is 55 years old, and he has been here in Georgia for more than 15 years. They have two minor children, and Your Honor, his wife is, I mean, they are legally married, and the property is, marital property. And his wife did not call the police, Your Honor. My client is graduated from high school, and then after that, he's been working as a manager at Family Dollar. He does have a stable income to take care of his wife and children, Your Honor. We would like to request for a signature on bond. He's doesn't have any failure to appear. He doesn't have a probation violation. This was done, I mean, if he has anything, it was kind of like really, really long time ago, like 25 years ago. Um, and this happened almost a month ago. So we asked for no further violent contact, and we would like to ask for a signature on bond.
All right, defendant is gonna receive a $6,000 surety bond. He's to have no contact with the alleged victim, stay away from that location. He can return one time with a member of law enforcement to get any items, and he can coordinate transfer of the children through the third party. He's to have no alcohol, no drugs, no weapons, and if this case can be readdressed at state all purpose on the 21st. Is there anything additional?
Honor, actually, his wife currently is at Mary Hall Rehab Facility. So nobody is actually, his wife is not there at the house. And she does, so that's why she's at rehab facility. It's not my client who has issues, Your Honor.
So she's at rehab forever, is what you're saying, Ms. Kim? Like she doesn't live at that house?
She does not live at the house. She is at rehab. Probably the program will last about 6 months to 1 year.
Okay, what I'll do is he can return with law enforcement to determine whether or not she's still residing there. If she's not there, he can return. If she's still there, he'll need to stay away and collect his items, okay?
Yes, Your Honor.
All right, best of luck to you, sir. That concludes your case for today.
Number 30, Mr. Singletary.
Yeah. All right, Mr. Singletary, your case is 26 CR 002291A. You're charged with criminal trespass. Do you understand your is he coming?
Okay.
Okay. You understand your rights, Mr. Singletary? All right, Miss Stallworth, can I have your history, please?
Yes, Your Honor. He has one prior arrest. It was a criminal trespass and simple battery out of the cab, but there is no disposition listed. That was in 2023. The recommended level is UJR jail.
Okay, thank you, Mrs. Rocco. Most concerned with where he was and how recently he had received the warning to stay away from there.
He had received it as recently as April 3rd, Judge, and this was the Altitude Apartments. Location is 250 Piedmont. He had been told several times also that same day, April 7th here, the date of the incident, that he needed to leave and could not return, but he returned once more. So that is in addition to the presumably open criminal trespass under the cab. Why we'd be asking for a signature bond through pretrial with a social worker visit for BHET and or housing. Stay away from the Altitude Apartments, 250 Piedmont Ave in Atlanta, and no drugs, weapons, or alcohol while out on bond.
All right, thank you, Ms. Kim.
I have no objection to signature on bond, Your Honor.
No, I'm not sure I'm gonna do that, so why don't you tell me about your client?
Yes, Your Honor. Mr. Singletree is 32 years old. He has been struggling with residential challenges. That's the very reason that he has this criminal trespass charge. He graduated from high school 2011, and then he went to Virginia Commonwealth University for a bachelor's degree. He does it. His major was public relations, Your Honor. He does not have FTA or probation violation, Your Honor. He's recommended for UJR jail, as you can tell. Your Honor, he went to the incident location with a law enforcement officer to retrieve personal belongings, and he had authority to be back there. But the police officer who was arresting him did not verify whether he was allowed or not. Just because there was a previous case, if the person who was charging, okay, um,
Please mute that, Ayana Graves, please. Continue, Ms. Kim.
Your Honor, and we would like to request, we have no objection to a worker visit for housing and BHET, and yet I strongly recommend for him to get a signature on bond. Without his job, he cannot pay for any of that right now.
And
Right.
Your Honor, none of that was stated in the warrant there. It says the officer witnessed the defendant on the property.
Okay.
Okay. All right, defendant is gonna receive $1 cash bond. He's to stay away from that location, have no alcohol, drugs, or weapons. Is there anything additional?
Doesn't he need a social worker visit for
Oh,
housing?
and a social worker visit, yes.
Your Honor, can he have at least one time law enforcement officer visit to retrieve his personal belongings, please?
All right, he can return one time with law enforcement only to get any items. All right, best of luck to you, Mr. Singletary. That concludes your case. Who do we have next?
25, Mr. Bless.
We don't have no way of contacting me. Come on.
Your Honor, Mr. Butler would like to speak for his son. Whenever you have, maybe you are, please allow him to.
Okay, in a minute. Let's keep going. That one, we keep circling back. Who do we have next?
25, Mr. Bless.
Okay, Mr. Pless, your case 26 CR002271J. You're charged with failure to yield, hit and run, and driving with no insurance. Do you understand your rights?
Yes.
All right, Ms. Stallworth.
Yes, Your Honor. He has 39 cycles total. There are 10 convictions outside of the 10-year period. The last date of arrest was February the 15th of 2024, and those charges were dismissed. The recommended level is level 2.
Okay. Mrs. Sirocco.
Yes, Your Honor. This was a February 14th incident. Took place along Custer Avenue in Moreland. And the officers were dispatched there in reference to a hit and run collision involving two vehicles. The victim's name is Anne Marie Iowa V, I believe. Either that or Iowa Yi, but I believe it's the former. She explained that she was making a right turn in her vehicle into the parking lot at the location when the defendant, who was operating 2009 Honda Pilot, wasn't paying attention and collided with her vehicle. The defendant had asked her not to call the police, stating to her that he did not have insurance and had drugs on his person, and was then pulled aside into the parking lot before leaving the scene without providing his information. She was able to take a picture of his vehicle's tag number. It was confirmed that that vehicle did not have valid insurance coverage. She That vehicle was linked to the defendant here, and there was a photo lineup that was administered to Miss Iowabi, and she confirmed the defendant's identity. Your Honor did hear 39 cycles. I see most recently, in terms of convictions, the 2017 simple battery conviction, but he's had parole violations pretty much all throughout the past, from 2017 to 2010. I counted roughly seven, along with other older felonies and other convictions. State's recommending $3,000 surety, $2,000 on the hit and run, and $500 on the driving with no insurance and the failure to yield. We would recommend no driving without valid insurance, as well as no drugs, weapons, or alcohol while out on bond.
All right, thank you, Ms. Kim.
Yes, Your Honor, my client, Mr. Pless, is 67 years old. He is currently residing at your location that we have addressed at Odyssey. It is a rooming home, and his income, because ever since he retired, he's getting Social Security income is very low. So he's qualified for public defender services, and he does not have a child to pay for his bond. He doesn't have anyone. He cannot remember anybody's phone number right now. So that's another main reason that he cannot get the bond paid for. He has been working as a landscaper. He also worked at warehouse, but at this point, he just volunteers without getting paid at Mountain Pleasant Church. He gives out the foods to the homeless. And Your Honor, he does have a serious medical condition that he has to address as well. We would like to request for signature on bond. I mean, 2017 is almost 10 years, Your Honor. He does need some second chance to get this straight. He has no objection to not to drive, Your Honor. Thank you.
Defendant is going to receive a $1,500 split bond. He's gonna make bond on 1,500 on count one, 500 on count two, that's surety. And on the driving with no insurance, it'll be a $500 signature bond through the jail. He does not drive unless he has valid insurance, and in light of the split bond, he's going to all purpose on the 21st. Best of luck to you, Mr. Pless. Who do we have next?
Your Honor, repeat those bond amounts.
It's 500 on each count. The first two are surety.
Thank
the last two is signature to the jail.
Okay.
And we have a sheriff's 10% program, Your Honor.
Yes, he can do it for that one.
Thank you.
All right, next we got number 4, Mr. Brown.
All right, Mr. Brown. Mr. Brown, your case is 26 CR 002288G. You're charged with battery, family violence, cruelty to children, and theft by taking. Do you understand your rights? All right. Is that a yes? You understand your rights, Mr. Brown?
Yeah.
Thank you, Ms. Sowers.
19 prior arrests, 2020 conviction out of Chatham County for receipt, possession, or transport of firearm, 2017 out of Cobb for hit and run, criminal trespass, possession of marijuana less than an ounce, driving while license suspended or revoked, and fleeing or attempting to elude, a 2016 out of Cobb for driving without valid license. There is an open case out of Cobb County for terroristic threats and acts, aggravated assault, receipt, possession, or transport of firearm, and interference with government property. There are 7 convictions outside of the 10-year period and a 2014 FTA out of Cobb. The recommended level is level 3.
Thank you. Ms. Tucker?
Yes, Judge, we're asking for a $2,500 good bond on count 1, $1,500 good on count 2, the cruelty and $1,000 on the theft by taking. That's a total of $5,000 good, with no further violent contact with Miss Nia Harris, and to stay away from the park at Galloway Apartments. That's 3168 Candlewood Drive in East Point. The facts allege this argument over the defendant offering another female a ride home led to the defendant taking the victim's phone, grabbing her, then throwing her down the hill in front of the home and in front of her juvenile cousin. The victim suffered several lacerations on her arm and her clothes were dirty. We did speak with Miss Martin Harris. She's denying the events in the report. She says that she fell down the hill. She is pregnant. She is currently pregnant. Yeah, she's 5 months pregnant with the defendant. She says she wants the defendant to come home, wants contact and a signature bond, but considering that history, the open felony terroristic threats, open ag assault, it's all one case, as well as the history. We are asking for that $5,000 total good bond. The victim did let us know she'd be here and that she did want to speak with you, Judge. But that's the state's recommendation.
The state's recommendation was no further violent or no contact whatsoever.
No further violent contact.
All right, Ms. Harris, if you wish to make a statement, please raise your right hand and unmute.
I'm here.
You swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
I did not press charges. I do not want to press charges. As far as Mark returning home, I need him here with me because he helps with my daily tasks. I'm doing pregnancy by myself. It's only me and him. I did not press charges, as well as the arresting officer did not speak to me first. There was another lady on the scene named Mia. And the little child is my brother. He does not currently stay here, and he is not always here. He was only here for this weekend.
Thank you. I appreciate you coming to court to make that statement, Ms. Harris. All right, Ms. Kim.
Yes, Your Honor. Mr. Brown is 36 years old, born and raised here in Georgia. Your Honor, he does have a total of 3 children, actually 3.5, since one of them is on the way. And he has to pay a lot of child support for other children, Your Honor. He has been working really hard as a cook and Wingstop, but because of his payment for child support and his responsibility, he still qualified for public defender services. After getting GED, only thing that he has done is almost working all the time. We would like to request for a signature on bond. Your Honor, I do understand there were some histories, and yet we would like to request for a signature on bond.
Defendant is gonna receive a $4,000 surety bond. It'll be $2,000 on count one and $1,000 on each remaining count. He's to have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons, and he's going to all purpose on the 21st. Is there anything additional?
And
to do either program or get it down to like $200, Your Honor. He is having a very difficult challenge here.
I understand it's gonna remain as set.
All right, 26, Mr. Ramsey.
Okay, Mr. Ramsey, your case is 26 CR 002273F. You're charged with reckless conduct, 2 counts, failure to use a crosswalk, and obstruction. Do you understand your rights?
Yes, sir.
All right, Ms. Doward.
No prior history, recommended level 1.
All right, thank you. Mr. Sirocco.
Yes, Your Honor. This incident took place April 5th, 3788 Campbellton Road in Atlanta. Officers were patrolling a teen block party at the location when a female attending that party approached the officers regarding a male with a firearm, gave a description, and said he was carrying a firearm around under his left armpit. The male, who was later identified as a defendant, was seen jaywalking on Campbellton. It was near the intersection of Campbellton Road and Fairburn Road, not using the crosswalk there. Officers were trying to approach the male. Defendant at that point began fleeing, running through traffic, and then proceeded to toss the firearm that was on his person near a Sandy's tire shop. The defendant continued the foot chase up through the Texaco gas station before he was ultimately detained, captured, and assisted to the ground by officers. The firearm was recovered. Multiple officers pursued him here, and it was a loaded firearm. Um, now, this is a public safety case running through traffic from police with a firearm and tossing that firearm, which was loaded. Um, that firearm could have gone off, could have hurt an officer, could have hurt pedestrians, motorists here. This is a public safety case, and we do take it very seriously, especially with the use of the firearm here. We are recommending on that basis a $7,000 surety total, $3,000 on each reckless conduct and $500 on the obstruction and crosswalk charges. No firearms while out on bond. No drugs or alcohol either, but no drugs, weapons, or alcohol. And we would ask that he surrender if there are any other firearms, any and all firearms, to the sheriff's office. That is all for this case, Your Honor.
All right, thank you, Ms. Kim.
I believe his parents and his family members are here to support him, Your Honor, on the Zoom. Mr. Ramsey is only 18 years young, and this was huge block party. There were lots of people, and he was just kind of intimidated and scared by the officers. Your Honor, he is um, right now 11th grade. I really want him to complete his high school, Your Honor. And he is also working at Jack's as a cook. He does have a child, 2 years old, so he is very diligent in terms of working and providing financial support for his child. We asked for a signature on bond, Your Honor. He has no extra funds to pay for the bond. This is kind of like a sudden and surprising. Um, and that's all I'll say, Your Honor, at this point.
All right, defendant's gonna receive a $7,000 signature bond at level 2 through pretrial services per judge. It'll be 300, I'm sorry, it'll be 1,500 on count 1, 1,500 on count 2. Okay, hold on, sorry, let me do this math again, I did that wrong. 1 second. 15 plus 3. I'm sorry, it's gonna be 6,000 total. So 1,500 count 1, 1,500 count 2, 1,000 count 3, and 2,000 on count 4 for the total of 6,000. At level 2, he is to surrender any and all firearms he may have. I'm gonna require that he also do 20 hours of community service, and he is also gonna be digitally monitored with the curfew of 9 p.m. to 6 a.m. unless he's at work or a school event. I am gonna, he's not, you say he's 18, Ms. Kim?
Yes, Your Honor.
All right, so he doesn't need a co-signer. All right, is there anything additional from the state or the defense?
No, Judge.
All right. Best of luck to you, Mr. Ramsey. That concludes your case.
Next is position 18, I'm sorry, 19, Ms. Hong, position 19.
Thank you, Ms. Hong. Good afternoon. Your case is 26 BR 002280E. You're charged with DUI, let's say. Do you understand your rights? Thank you, Ms. Stallworth.
2 cycles, total, no convictions listed. Last date of arrest was in 2012 for a DUI out of Duluth in possession of a Schedule 2 with no dispo listed. She was on the wrap services list this morning, and the recommended level is UJR jail.
Thank you. Ms. Tucker?
Yes, Judge, we're asking for a $2,500 good bond in this case. You did hear she had that prior, it was a DUI per se. I don't know the disposition either, but that was an arrest for DUI. The facts in this case, officers were dispatched to a welfare check, and they saw the defendant pulling up to also check on the person. While they were speaking with the defendant, they noticed slurred speech, bloodshot, watery eyes, a strong odor of alcohol. She admitted to taking 3 shots and 3 mixed drinks before driving. HGN did result in 6 out of 6 clues. She did refuse all the other tests. That's why it's just charged as a DUI less safe. But we are asking for that $2,500 good bond in this case,
Thank you.
with
Is
no
this-
drugs or alcohol while on a bond.
Thank you. Ms. Anthony?
Yes, Your Honor. She is a lifelong resident, graduated from Alpharetta High School, did complete up to her senior year in college in psychology and computer engineering. She is the manager and owner of a retail and beauty mall for over 5 years. Did provide that the address on file is a good address. Your Honor, given that there's no prior convictions and based on the report, it does not seem that anybody observed her actually driving. We ask that there be a signature bond granted in her case or the least bond the court's willing to impose.
Defendant's gonna receive a $1,500 surety bond. She's to have no alcohol, no drugs, no weapons. She's not a driver unless she has a valid license or permit issued by the state of Georgia. And her case will be reset to April the 21st. Is there anything additional? All right, best of luck to you, ma'am. That concludes your case for today.
How much for that again? I'm sorry.
1,500.
Security, right?
Yes.
All right, number 20, Mr. Kempson's next.
Mr. Kimpson, good afternoon. Your case is 26 CR 002284C. You're charged with battery and simple battery. You understand your rights? All right, Ms. Stallworth.
Yes, Your Honor. He has 14 cycles total. There's a 2021 conviction out of Fayette County for simple battery. There's an open case out of New York for larceny and criminal possession of stolen property. There's an open case from the city of Atlanta for theft by shoplifting. That arrest date was February the 10th of 2026. There's a 2019 NOLO out of Coweta County for theft by taking. A 2019 out of Fulton for obstruction of law enforcement officers. A 2018 out of Coweta for simple assault. A 2018 NOLO out of Coweta for simple battery family violence, a 2018 first offender out of Coweta for willful obstruction of law enforcement officers and battery family violence first offense. They were on the wrap services list this morning, and there are 2 convictions outside of the 10-year period. The recommended level is level 3.
Mrs. Sirocco.
Your Honor, this took place April 6, 2026. Location is the Wendy's at 5255 Old National Highway, South Fulton. The victim here, Miss Mahogany Della Pierre, explained that the defendant was a stranger to her, entered the business at the location and began harassing customers. She went to the dining area and asked the defendant to leave, and the defendant then struck her. It was on her right shoulder, and another employee thankfully intervened. He came in and struck the defendant in defense of her. The officer observed redness and bruising on Miss Delpierre's shoulder. She advised officers that he was no longer allowed on the premises. They did locate him at the China cafeteria along that same stretch of road. The defendant was arrested. You heard his history, several violent convictions, simple battery, simple assaults, simple battery. There's a simple battery family violence NOLO and a First Offender Act. It looked like that was revoked, at least as far as the obstruction, but there was the battery family violence charge there as well from 2019. And that's right. Yeah, he's got those presumably open cases out of New York. And we did speak with Miss Delapierre. She does not know the defendant. This was her first time seeing him. She explained she is a manager at the Wendy's and the defendant was causing a disturbance in the dining area. She went to defuse the situation and had one of her employees escort the defendant out of the establishment. And that's when he swung on her. She did send us pictures of the bruise that she received from this incident, and she should be on here if she wishes to make a statement. We would ask that the court sound for her. But this is a public safety case, Judge. The 2 are complete strangers. He has a history of violence, and we are concerned for the safety of the public for him to be walking around. The state's recommending a 4,500 total surety, 3,000 on the battery, 1,500 on the simple battery. Social worker visit for BHET. No further contact with Miss Delapierre. Stay away from 5255 Old National Highway. That is, again, the Wendy's in South Fulton. And no drugs, weapons, or alcohol while out on bond.
Right, is Ms. Delpierre present and wishes to make a statement? If so, please unmute. Okay, hearing, seeing none, Ms. Kim?
Yes, Mr. Gibson is 41 years old and he is currently residing with his mother at the address that we have in our file. He was born in New York, but he has been here in Georgia for more than 10 years and he does not have any child. Your Honor, he was expecting only $1,500 surety bond. There was only one charge and now we have two charges. Your Honor, he graduated from high school 2002, and he was working at Douglas Management as a doorman. He has been receiving disability checks, and it's not that much. And that's why he applied for public defender services, and he does take care of MH issue. So we would like to request for a signature on bond if possible. And if Your Honor is not inclined to give a signature on bond because of the history that includes better charges, we ask that the total bond will be remain $1,500. Thank you.
All right, defendant's gonna receive a $2,500 surety bond, 1,500, count one, 1,000 on count two. He's to stay away from that location, have absolutely no contact with the alleged victim, have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Mr. Kimpson. That concludes your case for today.
Next is position 24, Ms. Parker.
All right, good afternoon, Ms. Parker. Your case is 26 CR 002290C. You're charged with 2 counts of battery family violence. You understand, right?
Yes.
All right, thank you, Ms. Stallworth. Can I have the history?
One moment, Your Honor. There's no prior history recommended level 1.
All right, thank you. Mr. Sirocco?
Yes, Your Honor. This incident took place April 7th of this year at 5250 State Route 138. It's the Evergreen Commons Apartments in Union City. Officers were dispatched in reference to a domestic dispute. Upon arrival, officer made contact with the victim, Mr. Omarion Trammell. He lives in the same household that the defendant does there. They've resided together since late December of 2025. And the officer observed visible injuries on Mr. Trammell. There were cuts on his left and right jawline, a cut on his right hand, additional marks on his right hand, consistent with possible bite marks. These injuries appeared consistent with a physical altercation and also appeared recent. He initially stated that nothing had taken place, then claimed he was playing PlayStation 5 and that a metal controller caused his injuries. It's a plastic controller. The officer confirmed that, but even then, unclear how. He changed his statement again and claimed that his Yorkshire Terrier caused the injuries to not only his hand, but his face. Then made contact, the officer did, with the defendant, who claimed she had been asleep in the bedroom and didn't know what was going on. Officer read her Miranda warning and she agreed to speak with the officer, stated that Mr. Trammell was playing his game loudly, which caused an argument, and Mr. Trammell had entered the bedroom and continued to argue with her. Denied any physical altercation, but it's clear that there was one here based on the injuries and the totality of the circumstances, Judge. We're fine with a $5,000 total signature bond through pretrial, level 1, $2,500 each. Uh, we would recommend 2 days anger awareness, no further contact with Omarion Tyrell. Stay away from the Evergreen Commons apartments at 5250 State Route 138 in Union City, and no drugs, weapons, or alcohol while out on bond. We have not been able to reach Mr. Trammell as of yet. If we could sound for him if he's online and wishes to speak, Your Honor.
Okay, is Mr. Trammell present, wishes to make a statement? Hearing none, Ms. Anthony, do you object to the signature bond level one with the stay away and no contact?
Did you say no contact, Your Honor?
I did.
Could it be no further violent contact? Ms. Parker is currently 7 months pregnant. And it is the alleged victim's child. So just contact as it comes to in regards to like her prenatal care and them getting close to due date.
And again, Your Honor, we have not been able to reach
Yeah,
him.
right, I'm not gonna do that, Miss Anthony, without further information at this time. Again, contact can be revisited at a later date. This just happened yesterday. Okay, so what we're gonna do is defendant is gonna receive a $4,000 signature bond at level one through pretrial services. She's to have no further contact with Mr. Terrell. Again, that can be amended at a later date. She's to stay away from that location. Should she need to return, she can do so one time with a member of law enforcement to get any items. And she's to have no alcohol, no drugs, no weapons. The case will be reset for the notice. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, Ms. Parker. That concludes your case for today. Who do we have next?
22, Mr. Marlowe.
Mr. Marlowe, your case is 26 CR 002269A. You're charged with battery, family violence, battery against a pregnant female, simple battery against an old person or a person who was pregnant, cruelty to children, and simple battery, family violence. You understand your rights?
Yeah, ma'am.
All right, Ms. Stallworth.
There are 4 cycles. There is an open case, 25 PI 007537 for child molestation. They're on first offender probation for aggravated assault and cruelty to children 3rd degree. That was court ordered restricted. That case number is 25 SC 006935. The recommended level is level 2.
Mrs. Sirocco.
Yes, Your Honor. The incident here is alleged to have taken place March 29th of this year. 3200 Cushman Circle Southwest in Atlanta is the location. It's an apartment complex. Officers made contact with the victim, Miss Dominique Buford, who had visible injuries, including a blood clot in her left eye, noticeable swelling. And she explained the defendant, who is the father of her unborn child, with whom she previously lived and does share a 2-year-old, had asked to meet with her, and she agreed. That is her apartment complex there, though. That's where she lives. And the two were talking inside the apartment. The defendant became upset about a conversation she was having with her friend over FaceTime. It was at that point the defendant rushed towards her and punched her in the eye with a closed fist. After which she explained he threw her to the floor and she curled into a ball to protect herself. Her friend, who was still on FaceTime, told the defendant that she was calling the police. Officers, there was it appeared that the defendant at one point had jumped out of a second-story window, from what they could tell. This was, yeah, they were observing a broken window that had been lifted from the windowsill. Turns out when she curled up into a ball there, she was not just protecting herself, she was protecting her unborn child. She was 7 months pregnant on the date of the incident. Her son, juvenile AB, also was there and witnessed the incident. And thankfully he was unharmed, but they were transported to Wellstar Hospital for evaluation. We have not been able to speak with the victim thus far, but with the facts here, with him being out on first offender for the aggravated assault, family violence, judge, and the cruelty to children, which was to which he was sentenced, it was December 2025. So it's hasn't even been 5 months since he was released on that. The state's recommendation here, out of concern for the victim's safety, the risk of reoffense that's present, and our concern for the unborn child's safety as well, is going to be an $8,000 surety, 2,500 for each battery charge, that being the battery family violence and the battery against a female who's pregnant, and 1,000 for each simple battery charge, the simple battery family violence, and the simple battery against a pregnant person. And we're recommending $1,000 surety as well for the cruelty to children. Recommending, if he does bond out, FFIB, no further contact with Dominique Buford. Stay away from her apartment complex at 3200 Cushman Circle in Atlanta. No drugs, weapons, or alcohol while out on bond. If we could sound for Miss Buford.
All right, since Buford present wishes to make a statement. Ms. Kim?
Your Honor, Mr. Marlowe is 18 years younger, Your Honor. It really is kind of hard to say this is, he is probably residing with his mother. He was born and raised here in Georgia, and he is very good at football. Right now, he is 12th grade at Phonics Online High School. He is expected to graduate very soon. And he also works doing landscaping, but his income is very low, so he's still qualified for public defender services. He does have a child, um, one child, and then he's also expecting another child. So he does have very challenging financial circumstances right now. And we would like to request for signature on bond. And yet I do understand that it might not be, Your Honor might not be inclined to give him a signature on bond because of previous and open cases. We ask for the lowest possible bond, 500 each, $2,500 surety bond.
Right, 1 second. All right, defendant is going to respect. Defendant's gonna receive a $4,000 surety bond, 1,500 on count 1, 1,000 on count 2, 500 count 3, 500 count 4, and 500 count 5 for the total of 4,000. He's to have no contact with Ms. Buford, stay away from that location, have no alcohol, no drugs, no weapons. Is there anything additional?
Can you have at least one-time law enforcement officer escort to visit?
Yes, he can return one time with law enforcement to get any needed items.
And also a third-party transfer for his child.
All right, and he can coordinate transfer of the child to a third party.
Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 33, Ms. Waymeyer.
All right, good afternoon, Ms. Waymeyer. Your case is 26 CR 002295. Your charge of simple battery family violence. You understand, right?
Yes, I do.
All right, thank you, Ms. Stallworth.
There's no prior history, recommended level 1.
Thank you. Mr. Sirocco, please proceed.
Yes, Your Honor. This incident took place April 7th, 2026. The location is 6250 Peachtree Dunwoody Road in Atlanta. Officers responded to a domestic at the location and spoke with the victim, Miss Lois Waymeyer. It's the defendant's mother. They lived together at the location. She explained that the defendant had become physically aggressive with her after an argument. And while speaking with the defendant did admit to hitting her mother because she was upset with her due to Miss Waymeyer rushing her for a doctor's appointment. She stated the defendant has a history of, I'll say MH, which has been documented by medical professionals. She stated that the defendant threw a shoe and a shampoo bottle at her. There were no visible injuries. Defendant was arrested. We'd be fine with a signature bond on this case, Judge, through pretrial. We would recommend MHET in order to comply with any existing treatment, given what was stated by the mother to officers here. Um, Against my better judgment, I am going to recommend no further violent contact with Miss Lois Waymeyer. We haven't spoken with her yet. I hope she's online and she can address the court. But I want to make sure that the defendant receives the help that she needs, or at least continues to receive that help. If she is currently receiving it, I hope the defense can at least elaborate on that without going into specifics. No drugs, weapons, or alcohol while out on bond.
Is Ms. Waymeyer present, wishes or can make a statement? All right, Miss Anthony, you're muted.
My apologies. Yes, she is here. As stated, she is here to seek some additional help. She is scheduled for a clinical evaluation. She was able to get that appointment rescheduled, so we are no objection to the signature bond, and she'll continue seeking treatment and evaluation through her already scheduled medical health appointments.
All right, defendant's going to receive a $2,000 signature bond at level 1 through pretrial services. She's to have no further violent contact with the alleged victim, comply with any current treatment. I'm not going to do the MH quite at this time. She'll be reset for the notice. Is there anything additional?
Nothing
All
to
right.
say, Judge.
Best of luck to you, Ms. Waymeyer. That concludes your case for today. Who do we have next?
28, Mr. Shaw.
All right, good afternoon, Mr. Shaw. Your case is 26 CR 002276B. You're charged with making terroristic threats, acts, and simple assault. Do you understand your rights? Is that a yes?
No.
Thank you. Ms. Stallworth?
Yes, Your Honor, he has one prior arrest. There's a 2024 first offender out of Fulton for possession of firearm or knife during commission and hijacking a motor vehicle, second degree. That was court order restricted. The recommended level is level 2.
All right, thank you. Mr. Sirocco?
Thank you, Your Honor. This incident was April 6th incident from this year, 2395 Butner Road, and that's in Atlanta. The officers responded here in reference to an active disturbance, and they spoke with on scene juvenile DL, the female sister of the defendant. They lived together in that household. The defendant was verbally threatening their younger brother, who shares her initials as well. So he's also juvenile DL. With acts of violence, and that DL was in fear for his safety and currently hiding in the bedroom closet. Officers did locate DL in that closet and asked him to step out. He stated he was in fear for his safety, as the defendant stated he was going to attack him. When the officer questioned the defendant about these allegations, he stated, "Yes, I told him I was going to beat his ASS and I would kill him." While continuing the investigation, the officer observed the defendant become very irate, very aggressive towards his sister, DL, stating, "Shut the F up before I do something to you." Um, this threats to beat one sibling and who was found hiding in a closet in fear for his safety, explicitly, and insinuating violence against the other sibling. This seems to extend beyond a normal sibling dispute, beyond your ordinary one. And that elevates our concern here for this case. That, in addition to not having been able to reach a parental custodial figure here for juveniles with initial DL, that with his First Offender Act case, we are recommending a $2,000 total surety, 1,000 each. No further contact with either of his siblings at this point. I think that's something we can revisit down the road once there's been a sufficient cooling off period and we get a chance to speak with them. Stay away from 2395 Butner Road, Southwest in Atlanta, and no drugs, weapons, or alcohol while out on bond. If we could sound for any parent here on behalf of the juveniles.
Are there any parents present on the behalf of the juveniles involved in this case with Mr. Shaw? Okay, Ms. Kim?
Yes, Your Honor. Mr. Shaw is 21 years and he is currently residing with his mother and the sister, who is 17 years old. And the brother, another complaining witness, who is 16 years old, he does not live with my client. He lives with his grandmother. Your Honor, he does not have any failure to appear. He doesn't have any probation violation. And we would like to request for signature on bond if possible. He is after 11th grade, he has been pursuing his GED, but because of his disability, he gets Social Security income, which is still very low. So he's qualified for public defender services. He doesn't do any drug or alcohol, but he does not have a lot of income to pay for any bond. We ask for a signature on bond, and if Your Honor is not inclined to give him a signature on bond, we ask for max $1,000 surety bond, 500 each, Your Honor.
And
All right.
Your Honor, the just for clarification, the address listed in the incident report for both victims here is 2395 Butner Road.
All right, defendant's gonna receive $1,000 surety bond, 500 on each count. He's to stay away from that address. He can return one time with a member of law enforcement, and he's to have no further contact with either of the alleged victims in this case. Have no alcohol, no drugs, no weapons, and his case is going all purpose on the 21st. Mrs. Rocco, does the stay away address your concern?
Did Your Honor say no further contact, no further violent contact?
I said no further contact.
Yes, Your Honor, that's fine.
All right. Anything additional from the state of the defense?
Your Honor, he has no to reside. Can he have at least sheriff's 10% program?
No, he cannot, and I am gonna enforce the stay away at this time.
Nobody answer the phone.
All right, next we got 29, Mr. Sherman.
All right, Mr. Sherman, your case is 26 CR 002279A. You're charged with reckless is Mr. Sherman present? There you are. Reckless driving, reckless conduct, hit and run, erratic lane change, following too closely, and attempting to misrepresent a tag. You understand your rights? Thank you, Miss. You want to see Miss Stallworth still? Oh, I thought you left us. I didn't see you for a second. There, Miss
That's
Stallworth,
okay.
please proceed.
He has one prior arrest, which is an open case out of Fulton. There's no case number listed. It's for aggressive driving and fleeing or attempting to elude. Nothing further.
Thank you, Mr. Sarafa.
Yes, Your Honor, I saw the same, and I was looking for that case. I couldn't find it in our system, but I did see that on the GCIC. I did also see a prior speeding conviction from 2016 when we ran his history. The incident here took place April 6th. This was in the area of 1045 Woodstock Road in Roswell, also known as Highway 92. Officers were dispatched to the location in reference to a hit and run that had just occurred. They made contact with the victim, Mr. Wilson Betances Sr. He explained he was driving eastbound on that road in the middle lane when a red Ford Bronco rear-ended him, and at that point, it continued to push him into the right lane for approximately 100 feet. The driver was later identified as the defendant, had fled the scene of the accident, sideswiping the left side of the victim's vehicle also, and continuing eastbound on that road. An ambulance was called to the scene to aid the victim here, who complained of back pain. He was transported to North Fulton Judge. The defendant's vehicle was located actually by two witnesses who observed the hit and run. Timothy and Beverly Weaver. They saw the defendant pull out of a subdivision, turn into oncoming traffic. They witnessed him flipping off every driver on the road and weaving in and out of his lane before crashing into the victim's vehicle. and then fleeing down Highway 92. The Weavers followed the defendant to a secondary location, 880 Woodstock Road, in the parking lot in front of the AT&T store, and notified the department of the defendant's location there. The defendant claimed he had called 911, assumably about the crash. Officers looked in his phone. He allowed them to. And there was a 911 call that was placed prior to the collision here, Judge. And they confirmed that a piece of plastic also, which appeared to be a tail light, was lodged into the front of the defendant's vehicle. That piece matched with the victim's vehicle when it was brought to that vehicle. His left tail light, Mr. Batance's, and where it was broken and had a piece missing. His defendant also stated that his tag fell off during the collision using various resources, Roswell PD. His vehicle was last seen with the tag properly secured with 2 screws on it at 12:53 p.m. So just prior to this incident on the day prior. The officers searched the area of the incident and found no trace of the missing tag. Defendant was arrested there. I mean, this is insane behavior here, Judge. We hope Mr. Betances is okay. We have not been able to speak with him yet. We will continue those efforts. But this conduct here, as alleged, is with that and his history, that prior aggressive driving, fleeing, and eluding, he poses a risk to everyone on the road if this is how he's going around driving. So we are concerned for the safety of the public and as well for Mr. Betances, and we'll continue to try and reach him. We're recommending $6,500 split bond. That would be a $2,000 surety on the reckless driving, the hit and run, and the reckless conduct each, with a $500 surety on the attempt to misrepresent tag, and a signature bond through the jail on the improper erratic lane change and following too closely charges. We're recommending no driving whatsoever, as well as no drugs, weapons, or alcohol while out on bond.
All right, thank you, Ms. Kim.
Your Honor, Mr. Sherman is 47 years old and he is currently residing with his mother at Roswell. He has been here in Georgia for more than 15 years. He's not a flight risk, Your Honor, and previous driving record was more than 10 years ago. It's very remote. I think the no driving is kind of too harsh. I would like to request for driving for limited purpose, school, work, lawyer, medical reasons, Your Honor. We ask for signature on bond. He does not have a failure to appear, and he does not have any major convictions. He graduated from high school 1997, and he has gotten 35 credits for culinary school. However, he was working as a cook, but right now he has not been employed. He has been getting disability check because of his physical condition, Your Honor. And however, his paycheck is not that high. So he's still qualified for public defender services. He does have one son who is a minor, and he pays a lot of child support for that from, I guess it's from the state. They are paying for his child support. And he is caregiver for his mother, who is 80 years old. Since he's not doing any work, he helps out his family right now. We will ask for a signature on bond. Thank you.
All right, defendant is going to receive a split bond as follows. It's going to be 500 surety on count 1, 500 surety on count 2, 500 surety on count 3, 1,000 SOB through the jail on count 4, 1,000 SOB through the jail on count 5, and 1,000 SOB through the jail on count 6. So I bring it that he needs to make bond on the $1,500. The $3,000 is a signature through the jail for the total of that split bond as demarked. and he's not to drive unless he's going to work, medical appointments, legal appointments, or anything business related for business purposes. Is there anything additional?
Your Honor, can it be sheriff's 10%?
All right, I'll allow this one to go through the sheriff's 10%. All right. All
Thank you,
right,
Your
is there
Honor.
anything additional?
Nothing further from the bench, Your Honor.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Add on 2,
Oh,
Miss Mack.
all right, Miss Mack, good afternoon. Your case is 26CR002297J. You're charged with 2 counts of battery, 1 count of simple battery, and 1 count of theft by taking. You understand your rights?
Yes.
All right, Miss Stallworth keeps disappearing. There you are, Miss Stallworth. Please proceed.
There's no prior history, recommended level 1.
All right, thank you, Mrs. Rocco.
Yes, Judge, this was a February 11th incident from this year at 3379 Stone Road, Southwest in Atlanta. Officers responded to a fight call at the location. They spoke with witnesses who stated they observed 3 individuals, 1 black male, 2 black females physically attacking a young woman. And they spoke with the victim here, Miss Christina Ware. She explained the defendants, along with another woman identified as Savannah Daniels, who were effectively strangers to her, had assaulted her while she was in the vehicle with her boyfriend there. Defendant stated, and Miss Daniels, excuse me, the defendant and Miss Daniels began physically assaulting her and took her mint-colored Samsung Galaxy phone. They arrived when they arrived at the aforementioned location. Miss Ware's boyfriend went into an apartment. While he was inside, the attack continued. While outside the car, Miss Ware had physically punched and kicked, excuse me, the defendant had physically punched and kicked Miss Ware. Miss Daniels did as well. And while on the ground, Miss Ware was dragged by the defendant and Miss Daniels by her braids. That caused some of her hair to be pulled out. Miss Ware's boyfriend came out of the apartment, saw the commotion, got everyone back in the vehicle, and they drove off. Once they left, they arrived at a gas station somewhere in Atlanta. And it was somewhere during that exchange that they had taken Miss Ware's cell phone. And one of the women that was there had asked for the code to get gas to put in the car. She ended up giving it to them. And later saw that nearly $3,200 had been sent to Savannah Daniels, the other woman here. Miss Ware had sustained injuries, swelling to her face. They saw that also there were patches where her hair from the back of her head had been pulled out, and a portion of the attack was recorded. The defendants were identified via photo lineup, and warrants were issued for their arrest. We did speak with Miss Ware. She states that the defendant is her boyfriend's sister, and he knows her as Goldie. She knows her as Goldie, excuse me. She's only been with her boyfriend for around 2 months and recently met the defendant. The incident happened while they were driving in the car with her and her boyfriend and the defendant's friend, Miss Daniels. They had pulled into the apartments where the defendant was living. There was some prior verbal altercation, and she was attacked from the back seat. Defendant and her friend also pulled her out of the car and jumped her. She states they bit, punched her, pulled her hair, and she states that her scars are pretty much healed now, and she doesn't wish to be on Zoom. She is asking for no further contact and to stay away from her residence. I don't have that location offhand, but the state's recommendation, given that this was a group beating, we are, as you've heard from ASG Tucker, we have not been able to hear back on felony transfer requests today with Edie Hutcherson being out. But we did send one for this as a party to a crime with the theft of the $3,100. We'll hear back from him hopefully soon. We're recommending a $3,500 surety total, 1,000 on each battery and 500 on the simple battery, as well as 1,000 on the theft by taking. 3 days anger awareness, no further contact with Christina Ware. Stay away from Miss Ware's residence, and no drugs, weapons, or alcohol while out on bond. I don't believe she's on, but if we could sound for her just in case.
Is Ms. Ware present? All right, hearing none. Is this Ms. Kim or is Ms. Anthony? Please
Yes, Your
proceed.
Honor. Ms. Mack does retain her innocence in this, stating that she does not have any relationship with Ms. Ware. She did attend Creekside High School. Her mother is nearby, Your Honor. With the suggested conditions, Ms. Mack is experiencing some financial instability and will likely not be able to comply with the classes, the cost of each of the classes. So we just asked for a signature bond to be granted in her case.
I believe that class is free through pretrial, so defendant's
Okay.
gonna receive an $8,000 signature bond at level 2 through pretrial services. She is gonna take 3 anger awareness courses, have no contact with Miss Ware, stay away from wherever Miss Ware resides, and have no alcohol, no drugs, no weapons. Is there anything additional?
No, Judge.
Your Honor,
It's two,
break that bond down, please.
2,000 each count.
Thank you.
All right, best of luck to you, ma'am. Who do we have next?
$32 and add on Mr. Woodruff.
Okay, so Mr. Wardrick has 2 cases, 26 CR 002278B, in which he's charged with battery family violence and 2 counts of simple battery family violence. He also has add-on 3, which is 26 CR 002298B, in which he's charged with 2 counts of simple battery. You understand your rights today?
Yes, I do.
All right, thank you, Ms. Sauer.
There are 7 cycles total. There's a 2013 conviction for criminal trespass, and the last date of arrest was in 2020 from the city of Atlanta for possession of marijuana less than an ounce. That was dismissed, and there's an '09 FTA out of the cab. The recommended level is level 1.
Thank you. Mr. Sirocco?
Yes, Your Honor. Even though it's out of chronological order, I'm going to start with the case on the main calendar. This incident took place April 6, 2026, 3215 Cushman Circle in Atlanta is the location. It's an apartment complex. Officers had made contact with the victim, Miss Ayanna Graves. She explained to the defendant, who is her now ex-boyfriend of 2 years, they've been living together at the location, had gotten into a verbal dispute. Well, she was on the phone, and the defendant had approached her and grabbed the phone out of her hand. She asked him multiple times to return it. At that point, she went and contacted the police. Further stated that later, a male friend had come by, he was no longer on scene when officers arrived, but he came by to bring her cigarettes. The defendant came out of the home trying to fight the male, and she tried to walk away from the situation, at which point he came up behind her, began pushing her with both hands, and telling her to get back in the home. When she refused, grabbed both of her arms tightly, began pushing her into the home. Officer observed red and colored bruising on both of her arms, consistent with her statement. And she stated that when she was grabbed and placed back in the apartment, argument continued, and that the defendant continuously threatened to break Miss Graves' televisions. The defendant was overheard stating out loud, following his denial of the incident, "You told me," this is to the victim, "you told me you were going to tell the police nothing happened." Ms. Graves stated in response that she said that to get him to calm down and to leave her alone. As for the April 4th incident, so just 2 days prior, Your Honor, that was also at the same location. It was also against the same victim. And she had reported that the defendant had been drinking for several hours and making threats towards her. And while she was inside her room, Mr. Wardrick came inside and grabbed her from the neck, by her neck, and that he also grabbed her arms, trying to push her down, pin her down. The officers arrived on scene, and when they did see that Mr. Wardrick was heavily intoxicated, could barely stand on his own. He was belligerent and irate because Miss Graves had called the police. Um, the officer in this, the initial responding officer in the April 4th case, I will say, for whatever reason, did not think he had probable cause here. This was reviewed by a supervisor subsequently, and warrants were issued for the defendant's arrest. As you know, but the testimony of one witness is enough to prove a fact and evidence here, Judge, and she gave these statements to police. Uh, we did speak with Miss Graves. She and the defendant had been broken up for about a week. She referenced the April 4th incident when we were asking her about the incident on the 6th, and they'd been together for 2 years prior to this. They share no children. They lived together, and the defendant had, she stated, never been violent with her before. But the defendant was under the influence of marijuana and alcohol during these incidents. He drinks and smokes heavily, according to her, and she thinks the defendant was mad because he had to give the victim money for rent, previously borrowed from her. She still has the bruises from the second in time incident on the main calendar. And we did follow up when we saw that there was this other case with respect to um, the, uh, the April 4th incident. This was, you'll notice it's an add-on. But when we found that and the facts of that, we did call her up again and conduct a strangulation assessment. She stated the defendant pushed her down, had gotten on top of her, and started choking her. It was one hand around her neck for a period of roughly 10 minutes duration, and it was on and off in that time. She rated his grip strength as a 10 out of 10, caused pain in her neck, and that the defendant was screaming, "I hate you," throughout that ordeal. Um, and she did say that she wants no contact as well as a stay away, and is okay with a one-time police escort. I know she wants to make a statement here today. I believe I saw her online, if we could sound for her when appropriate. But with this being two incidents, one basically right after another with a day's gap, the two violent incidents against the same victim here, we are very, very concerned for her safety. There is a risk of reoffense, and we are therefore recommending a 7,500 total surety between the cases. The breakdown being on the main calendar. That case, $5,500 surety, that being a 3,500 on the battery family violence and 1,000 on each simple battery family violence. As for add-on three, we are recommending $1,000 surety for each simple battery family violence. Your Honor's well aware of the increased lethality risks associated with a possible strangulation case, and we'll be looking into this further with any possible felony transfer recommendation. We're recommending FFIB, no further contact with Ayanna Graves, stay away from that apartment complex, 3215 Cushman Circle in Atlanta, as well as random screens for drugs and alcohol here, Judge. No drugs, weapons, or alcohol, and I do see Miss Graves.
All right, Ms. Grace, if you wish to make a statement, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, yes, Your
Again,
Honor.
again, I'm most concerned with desire for contact and concerns you have for your safety. In light of those instructions, what would you like to tell me?
Your Honor, Rashawn and I have been together for almost 3 years, and he has never done any physical harm to me before. And the only thing that I want in this case is for him to seek some type of drug treatment and some type of alcohol treatment, and for him to just stay away from me.
Then I appreciate you coming to court to make that statement. Is this Ms. Anthony's case or Ms. Kim? Please proceed.
Yes, Your Honor. My client is 41 years old, and we have no objection to stay away and no contact with alleged victim, Your Honor. We just need one time law enforcement officer escorting visit to retrieve his personal belongings. And Your Honor, I believe he graduated from high school 2003, and after that he has been working as a cook at McDonald's, but because of this arrest, he believes that he kind of lost his job. He doesn't have any failure to appear or probation violation. We asked for a signature on bond for the first April 4, 2026, and hopefully signature on bond for both. But if Your Honor is not inclined to give him a signature on bond, we ask for the maximum $1,000 surety bond.
All right, on the case that's on the main calendar ending in 2278B, defendant's gonna receive a $2,500 surety bond, 15 on count one, 500 on each remaining count with a total of 2,500. He's to have no contact with the alleged victim and stay away from that location. For the case on the add-on calendar, defendant's gonna receive a $2,000 surety bond, 1,000 on each count with the same conditions. He's to have no alcohol, drugs, or weapons, and both cases are going to the state all purpose on the 21st. Is there anything additional as it pertains to Mr. Wardrick?
I don't believe so, Your Honor. Are we going to deal with the at a later date the substance abuse issues? Is that
I think so, because until I'm not going to send him through pretrial. There's no other way for us to really monitor that. He could do it out ADET, but I'm not going to do that at this juncture. All right.
Excuse me, Your Honor, did you say 2,000 total on that add-on?
Yes, ma'am. 1,000 each count.
Thank you.
Thank you,
All
Your
right.
Honor.
All right. Best of luck to all parties concerned with this case. This matter is closed for today.
Thank you, Your Honor.
All right. Who do we have next?
We go on the waiver cases. Start with number 13, Mr. L. Birch.
Okay, before we go to the waive cases, let's go back to the, Ms. Kim, were you able to find a different co-signer for Mr. Butler?
We tried really hard. Both mothers are here, and they do have somebody at South Carolina or New Jersey, but nobody's here locally. So
All right, his father is present. What is his father's name? Mr. Butler, you're present?
Yes.
All right, please unmute. Please unmute, Mr. Butler. And I'm just to be clear, all the rest of the cases are waivers. Is there anybody who bonded out?
Yes, position. Oh,
I'm sorry, what position bonded out?
Corliss Brown.
Okay. And are there any other announcements or all the rest are waivers?
Yeah, Mr. Core is gonna get medical. He's at Grady.
Medical reset, okay. And so then we had 13, which was a consent. 21 is a waiver.
Yes.
Okay. All right. All right, Mr. Butler, please raise your right hand. Do you swear or affirm the testimony gives today be the truth to the best of your knowledge?
Yes.
All right. So do you have concerns for your safety and do you wish to have contact with your son?
Me and my wife don't have any concerns for our safety. We just want our son to graduate school, and then prior to that, we plan on going into the military, which he took the ASVAB test for already. He graduates next month. He's 5 credits away from graduating.
Okay. I'll change that for position 5 to no further violent contact with his parents. And I'm gonna allow Mr. Butler to serve as a co-signer for that particular case, all right?
Thank you, Your Honor.
All right. All right, best of luck to you, Mr. Butler and Mrs. Butler. Your son is
Thank you.
getting a signature bond with some conditions. All right,
Thank
let's take up the case for number 13, which was a consent 26 CR 002272C, in which defendant was charged with criminal trespass. Very quickly, Ms. Stallworth, can I have that history, even though it was a consent?
Yes, Your Honor. He has 4 cycles, open case out of Brookhaven for disorderly conduct and willful obstruction of law enforcement officers, an open case out of Fulton for criminal trespass, 25 CR 005963C, and another open case out of Fulton for criminal trespass and willful obstruction. I did not have a case number, and the recommended level was level 2.
All right, thank you. Ms. Tucker?
Yes, Judge, you heard there was no violence in that history and no violence in the facts of this case either. So we're recommending $1,000 signature bond through level 1 with a stay away from 3205 Peachtree Road, Atlanta, which I believe is a florist shop.
Okay. And have the defendant, Miss,
Yes,
I'm sorry,
yes.
Miss Stallworth, any prior criminal trespass?
Your Honor, just the open case, 2 open cases.
But they're not they weren't criminal trespass,
They
were
were.
they? They
They were.
are?
Mhm.
All
Yes.
right, so then he does have to go through pretrial. All right, he's gonna go through pretrial at level 1. Is that the understanding, Ms. Kim?
Yes, Your Honor.
All right, best of luck to that defendant. Please let him know. We'll take up wave case 26 CR 002286F, the case in which Michael Lewis is charged with battery family violence and simple battery family violence. Ms. Stallworth?
Your Honor, I'm trying to do it. Okay, he has 27 cycles total. 2019 conviction for possession of cocaine out of Fulton, a 2019 out of Fulton for purchase, possession, manufacture, distribution, or sale of marijuana. There are 8 convictions outside of the 10-year period. There is an open case 26 PI 002130 for criminal trespass, possession of a Schedule 1, possession of a Schedule 2, trafficking controlled substances, possession of a firearm, and willful obstruction of law enforcement officers. And then there's another open case, 23 SC 185706, possession of cocaine with intent to distribute, willful obstruction of law enforcement officers, and possession of marijuana less than an ounce, and '05 FTA, and it was bail restricted.
All right, thank you. Mrs. Sirocco?
Thank you, Your Honor. And let me, I'll get to that in a second. This incident here took place March 12th through March 13th of this year. The location is 515 Mount Zion Road in Atlanta. Officer made contact with the victim here, Miss, it's a Irish or Gaelic name, Siobhan Gibson. I'm sure I'm butchering that, but she explained that the defendant, who is her ex-boyfriend, who used to live with her for roughly 4 to 5 months, had come to her residence and broken her bedroom window. She had explained the defendant stated he would pay to have her window fixed. They got into a verbal dispute that escalated into physical contact on March 13th. So Miss Gibson had stated during the physical altercation the defendant had thrown a shoe at her. That hit her in the left eye, and the officer saw bruising on her left eye. Took photographs of the injury. She and the defendant dated for a year and a half and ended their relationship just a month prior to this. I do see that while these are outside of the 10-year window, I do want to make Your Honor aware of the aggravated assault conviction 2010, sentenced to 4 years confinement, another aggravated assault conviction, along with cruelty to children in the third, 2006. And a battery, it's listed as a battery slash simple battery family violence in Odyssey, or excuse me, in the GCIC, but it's listed in Odyssey as a battery family violence. And where he was sentenced to 24 weeks DV counseling. We're looking into that documentation because if it is a battery family violence, then this would qualify as a recidivist family violence offense here, Judge. And I did see as well 2026, 2005 FTAs. But a little bit more on that. One of the open Fulton County cases, 26 PI 0012, excuse me, 002130. That criminal trespass charge, it's grouped in there with a bevy of drug and firearm possession charges. Um, that's against the same victim as here. That was for entering her home. Notably, he had a firearm in plain view in the vehicle at the time. And there's other property damage allegations here that were referenced when we received the incident report from him entering her property to a work laptop. And there was footage of him entering the home. I also see that he has a hold for out of Athens. It's for a child neglect case, Judge. Additionally, we also listened to the jail calls here. Defendant had contacted the victim, interrogating her about what she told the police, and once he saw that an additional charge had been filed. He also, in the course of that conversation with the victim, admitted that he became frustrated, believed she was being unfaithful, and admitted to putting his hands on her. Then they discussed his custody status and Clark County case. The state's recommendation is based on the risk of FTA here, in part with the two FTAs, the 2026 and the prior one as well. We are concerned for her safety, with this seeming to be one incident in a pattern of criminal trespass, family violence, and family violence against her. We're concerned for reoffense here and for her safety. So the state's recommendation is going to be a $7,000 total surety, 5,000 on the battery family violence, and 2,000 on the simple battery family violence. We would recommend FIB as well as no further contact with Miss Gibson. Stay away from 515 Mount Zion Road, Southwest in Atlanta. And no drugs, weapons, or alcohol while out on bond. We haven't spoken with Miss Gibson yet. We'll continue those efforts to do so, but if we could sound for her.
All right, is Ms. Gibson present, wishes to make a statement? Hearing none, Ms. Kim?
Yes, Your Honor. Mr. Lewis is 40 years old. We have no objection to stay away and no contact. We will honor that order. My client is currently residing at another location with his 3 minor children, Your Honor. And after getting GED, he has been working at Tire King of Atlanta, and he has forklift certification, CDL. He wants to drive. He's kind of preparing to drive truck someday to make more money. As of now, because of low income, he's still qualified for public defender services. Your Honor, I do not want all those remote cases to prejudice my client. He does have a lot of bigger fishes to fry. There were so many bonds for other 2 felony charges, and also he has a failure to appear. And then also because of Boring County, they want to actually take him today. So we were hoping we get signature on bond for the condition that he will be only released to Clark County jail. I believe last Friday, his failure to appear was actually taken care of. Warrant was set aside, reinstated for original bond. He's just ready to go to Clark County, Your Honor.
All right, I understand that, Ms. Kim. However, defendant is going to receive $1,500 surety bond, 1,000 on count 1, 500 on count 2. He's to have no contact with that victim, stay away from that location, and have no alcohol, no drugs or weapons. The case will go to SAP on the 21st. All right, that matter is concluded. Let's go to position 31, which
Your
is,
I apologize, but can he have a third party transfer? He does have one child with her.
all right, yes, he can do the third party transfer. Thank you, Ms. Kim.
Oh, and Ms. Kim, just FYI, it doesn't look like it seems that FTA is still in place, at least according to his jailing.
Oh, okay.
So I don't think that's
All right, number 31 is waived too.
Yes, Your
Mr.
Honor.
Ricky Smith.
Yes.
All right, we'll take up 26 CR 0022948, in which Mr. Ricky Smith is charged with simple battery. Ms. Stallworth.
Yes, Your Honor. He has 58 prior arrests, several current probation cases. The first one is for terroristic threats and acts and willful obstruction of law enforcement officers. There's one for criminal trespass. There is another one for criminal trespass. And there's one out of Clayton County for burglary. There's a 2019 conviction for criminal trespass and willful obstruction, a 2019 for simple assault, 2017 conviction for criminal trespass, 2022 for simple assault and obstruction of law enforcement officers, a 2019 disorderly conduct. There's a 2016 criminal trespass, two of those, and two 2018. One is for possession of a Schedule 1 or 2, and the other is for sale of marijuana and possession of marijuana within drug-free commercial zone. And the recommended level is level 3, and then there are eight other convictions outside of the 10-year period, as well as two open cases for aggravated battery and criminal trespass out of Union City.
All right, thank you. Mr. Sirocco.
Yes, Your Honor. Yeah, quite the robust history here. The incident took place April 3rd, 2026. This was at East Point jail. Um, I would say fight, but it was entirely one-sided from what was described and witnessed here. The staff heard a verbal altercation between two individuals, Mr. Robert Williams, the victim, and the defendant. Staff observed the defendant standing when they arrived from where the altercation was coming from. He was standing on a chair and striking him, Mr. Roberts, on the left side of his face, specifically in the temple area, with a closed fist. They intervened and separated both of them. Mr. Roberts did not strike back. And there was, this is apparently over some disrespectful comment regarding gang affiliation, according to admittedly from the defendant, that led to this altercation. With his violent history here, I do see quite a few recent violent convictions that felony terroristic threats and acts. As you heard, he was sentenced to 8 years probation, MHET, and MH with an MH probation officer. That simple assault, and that was 2025, as recent as last October. And that simple assault obstruction conviction from 2019, there was a terroristic threats and acts, Noel Prost. Oh, excuse me, that was a different case. But he was convicted on criminal trespass, disorderly conduct, and obstruction on that case as well. With his FTAs, violent history, presumably open cases here, not just for felony violence, but for felony violence in a penal institution, seen out of Clayton, 2023. State's recommending a $4,000 surety, social worker visit for BH. No further contact with William Roberts, excuse me, and for the jail to separate the inmates if Mr. Roberts is still incarcerated there. No drugs, weapons, or alcohol while out on bond. I believe that's all for this.
Right. And Mr. Roberts was another inmate, correct?
That's yes.
All right. All right. Ms. Kim.
Yes, Your Honor. Mr. Smith is 32 years old, and I agree with the social worker visit. He's actually looking for a drug program so that way he can get help. He does have a ninth grade education. He successfully completed GED, and then he worked in landscaping. However, at this point, he does not have any employment. Um, Even though he has three children, he's not able to pay any money right now. We asked for signature on bond, and yet we do understand that he's not qualified for signature on bond, so we ask for the lowest possible bond. No matter what bond he gets, it will be like a no bond to him. So $1,000, $500 surety bond, and the complaining witness is actually went to another jail, so there's gonna be no contact.
All right. I'm still gonna issue the no contact and have the jail separate in the event that he does come back, but defendant is gonna receive a $1,500 surety bond with that condition. Of course, no alcohol, drugs, or weapons. Is there anything additional?
Nothing further from defense, Your Honor.
No, Your Honor.
All right, I believe that's the entire SCA calendar. Have we missed any positions, Ms. Bridgewater?
I believe that's it, Your Honor.
All right, hearing none, will you please review for me?
It will be my honor. Okay, once again, the reset date for the SAP calendar is going to be April the 21st. Position number 1 is going to the SAP calendar with a $25 cash bond. Position 2 is reset further notice with a total $3,000 SOB through pretrial. 3 is being reset further notice. The defendant was released. 4 is going to the SAP calendar with a total $4,000 good bond. 5 is reset further notice with a total $4,000 SOB through pretrial with the co-signer being Daquan Butler. 6 is going to the SAP calendar with a total $1,500 good bond. 7 is being reset till Friday. 8 is going to the SAP calendar with a total $2,500 split bond. 9 is going to the SAP calendar with a $1,500 good bond. 10 is going to the SAP calendar with a total $1,000 cash bond. 11 is going to the SAP calendar with a total 25. Okay, 11 is going to the SAP calendar with a total $2,500 good bond. 12 is a consent bond with a $1,500 SOB through pretrial. 13 is a consent bond with a $1,000 SOB through pretrial. 14, a consent bond with a $1,500 SOB pretrial. 15 is a consent bond with a $2,500 SOB through pretrial, and the cosigner was waived. 16 is going to the SAP calendar with a total $2,500 good bond. 17 is reset further notice with a $2,500 SOB through pretrial. 18 is a consent bond with a $1,500 SOB through pretrial. 19 is going to the SAP calendar with a $1,500 good bond. 20 is going to the SAP calendar with a total $2,500 good bond. 21 SAP calendar with a total $1,500 good bond. 22 SAP calendar with a total $4,000 good bond. 23 is going to the SAP calendar, and I corrected that amount, Your Honor, with a total $2,500 good bond.
That's correct.
Okay. 24 is reset further notice with a total $4,000 SOB through pretrial. 25 is going to the SAP calendar with a total $1,500 split bond. 26 is a $6,000 SOB through pretrial per judge. 27 is going to the SAP calendar with a total $1,500 good bond. 28 SAP calendar with a total $1,000 good bond. 29 is going to the SAP calendar with a total $4,500 split bond. 30 SAP calendar with a $1 cash bond. 31 is going to the SAP calendar with a $1,500 good bond. 32 SAP calendar with a total $2,500 good bond. 33 is reset further notice with a $2,000 SOB through pretrial. Now to the add-on calendar. Position number 1 is going to the SAP calendar with a $6,000 good bond. Position 2, reset further notice with a total $8,000 SOB through pretrial. And position number 3 is going to the SAP calendar with a $2,000 good bond. Are there any questions, comments, or otherwise?
Number 1, can I get that again?
Position number 1 is going to the SAP calendar with a $25 cash bond.
Okay, thank you.
Are there any
Questions?
others?
Hearing none, we'll be in recess until SAP calendar on Friday. Take care, everyone, and have a great afternoon. Bye-bye.
Thank you, Your Honor. Bye, everyone.
Goodbye.